that we would request the court to consider an OR bond on this case pending sentencing for a couple of different reasons. First and most importantly is his wife has congestive heart failure. She is quite ill. She does require essentially round-the-clock care. It's been hard for them to get assistance for her while he's been incarcerated. I think he's been in just close to 2 months, maybe a bit shy of that, around 60 days or so. He is staying in Middletown. The Eldora Drive address, I believe, is the current address that we have for him. He's currently unemployed. He had recently had back surgery in May. There's an outside possibility that he might have MRSA, so him being in the jail population probably isn't in the jail's best interest, and so that he can get treatment for that. As he did mention, he is in college. He's doing the University of Phoenix online for business administration. If he doesn't get back in his classes pretty soon, he's going to no longer be in the program, and he is working hard to, set him up for future success.
Does the state wish to be heard on the issue of bond?
Move to defer the court, Your Honor.
Okay, Mr. Likens, I am going to grant that request, and I'm going to modify the bond to be an OR bond with pretrial supervision at this time. So when you are released from the jail today, you need to come back over to this building and check in with court services and schedule your pre-sentence investigation interview and assessment. You understand?
Yes, sir.
And you heard me tell the gentleman before you, I did the same thing. If you don't show up for your pre-sentence investigation, you don't show up for sentencing, we'll issue a warrant. We will not have this conversation a second time. Do you understand that?
Absolutely, sir.
All right.
Your Honor, I'm sorry, we do have one thing. The pretrial services investigation for purposes of the arraignment indicates that there's possibly a Middletown warrant with adjacent counties for a few misdemeanors, but yet a false statement, which is an M1. This paper does show that is an adjacent county pickup. So in the event that Middletown does come to pick him up, may he appear pretrial the first date he's out from Middletown?
Yeah, of course.
All right, thank you.
All right, let's get this done, okay?
Thank you, sir.
Thank you, Your Honor. So I'll have it scheduled. Yes, okay. All right. See you later. I'll see you in a few weeks. Okay. Is that 4 or 9?
This is case number 20CR37378, the state of Ohio versus Clifford Estel, right? I'm sorry. Mr. Estel is before the court with his counsel, Mr. Ocello, Ms. Nicholson, on behalf of the state of Ohio. We're here for a final probation violation hearing. Mr. Ocello, we've had some lengthy discussions in chambers with regard to Mr. Estel. What do you want to do today?
Your Honor, we are going to ask the court to continue this matter so we can figure out the results of what may be going on in Hamilton County in front of Judge Dinkelhocker. I would ask the court to consider releasing Mr. Estel today. As the court is aware, pursuant to our discussions, he has a outstanding capias from last Wednesday on a new indictment, which is part of the rules violations that he faces here today before this court. He had posted bond down there. I've had contact with his attorney. In spite of having posted bond and knowledge that Mr. Estel was here, Judge Dinkelhocker in Hamilton County did issue a warrant for his arrest. So if the court were to grant us some additional time, I'm sure the court's aware that he will have to answer the warrant there before a resolution is reached here.
Ms. Nicholson, does the state have a position?
We did have lengthy discussions in chambers. Obviously, once he goes to Hamilton County, it is very difficult to bring him back here. We would ask the court place a holder once he gets to Hamilton County to ensure that once the Hamilton County case is resolved, that he reappears in this court. And I don't know how long the Hamilton County matter is going to take. So I don't know if we want to set a status. Because I think once he goes to Hamilton County, we kind of lose him.
All right. Mr. Estel, do you have any questions? One of your violations are these new felony charges in Hamilton County. I've given Mr. Ocello, obviously what Judge Dinkelhocker does is going to have at least some effect what this court does. So I tend to agree with your counsel. So what I'm going to do today is I'm going to continue this final probation violation hearing, and I will order you released from the Warren County Jail today. I will tell you that if Hamilton County does not come pick you up, you're not going to get out of the jail. So we need to check if they come get you, then you'll be down there. And then as soon as you are released from our jail, there's immediately going to be placed a new holder on you from Warren County. You understand that?
Yes, sir.
So you're not. So even though I'm releasing you today, you're not getting out of jail because I want you to deal with this charges in front of Judge Dinkelhocker, and then you could be brought back up here to face this violation. Okay? Does it make sense?
What's the violation on this case?
This case, number one, the new charges in Hamilton County,
Yes, sir.
which are the same. One of them's the same charge that you were convicted of here, which is concerning. But that's why I want to wait to see, because you have the presumption of innocence. So I want to wait and see what happens on that charge. The other allegations in this case is that you did not complete the substance abuse disorder treatment that I ordered, and the thinking for a change class that you were ordered to take. Now, again, I know there's some question in your mind as to whether you actually did those. You need to sign a release and allow Mr. Ocello to get whatever information he can, because if you did that under your courtesy supervision in Hamilton County, I don't know about it, and Mr. Ocello doesn't know about it, but he needs to find out about it. So you need to sign a release and allow him to talk to your probation officer down there, because they were doing courtesy supervision. But we have no information. Our probation department has no information that you completed those.
To my knowledge, but the probation I had down there, I thought he was giving reports to other probation here.
There's nothing in those reports that indicate that you completed the treatment that I ordered.
I completed.
I don't want to argue with you.
Right.
I'm just telling you, Mr. Ocello needs that information as your attorney. So you need to I'll give him permission, a release of information, so that he can talk to your PO down there.
Okay.
You understand?
Yes, sir.
Any other questions?
No, sir.
All right, I'll see you in a few weeks. Release him.
You want the entry, the violation?
Yeah, I think it's our initial appearance. So I'm gonna call and get over. Talk to me about it. I didn't know that. It's been up a second, 9:16, 9 o'clock.
See, the thing was set back in July. Yeah, so an initial appearance back in July. So it's set for an announcement today.
I believe Mr. Adams was unable to be here and I didn't do it. And so
Why did we give it an announcement?
No, I didn't want to make an announcement today. Just what I was gonna ask is, can I place it on another announcement docket? I did get all the written discovery from Mr. Ham. At some point in time, I'm about to get with Mr. Ham to go look at the video, looking at the nature of the charges. But what I did want today, Judge, is my client is a college student in Dallas. And with the internet restriction, then that kind of interferes with him being able to do his schoolwork in his classwork. So I do want to be able to use the internet for purposes of, what college you go to?
University of Texas at Arlington.
Yeah, University of Texas at Arlington. So with him being a college student, he would need access to the internet at least to complete his college assignments. So he would ask you to let him use the internet for the limited purpose of submitting his college assignments.
Yeah, I police that.
Because
No, police that. He got in trouble for doing it. And that's why he's in trouble, uploading a bunch of child pornography on the internet, right?
Yes, sir.
You're looking at 10 years in prison. I mean, and you're in college, you made a decision like that after being in an institution of higher learning. That's just not showing wisdom, is it? Fix it.
Listen,
You're smarter than that, aren't you?
no, sir. And Judge, only reason I asked because he's a recent graduate from.
Yeah, I know. You know what what, you know why the law was
No,
included.
I totally.
Children are victimized.
Absolutely.
Nobody's sympathizing with him.
No, I
They're
understand.
sympathizing with all the victims, the children who have been perpetrated as victims by the use of pornography, child pornography, and the accessing of pornography. Well, if you're so smart, you shouldn't be using a dadgum computer for that. Should be
And just,
learning to make better choices in life.
and just the only reason
Anyway,
I requested that because he just recently graduated from Kelly.
so
He's not-
what's his restriction right now?
Well, to my understanding, he can't use the internet at
How do
all.
we do that? How are we policing that?
Because now with
No, how are we policing that? He can get somebody's user ID and password, and how do we know it's him? See, that's the point. Is I don't understand how that's enforceable, but
and the only reason I asked that, Judge, is that I use my son.
I know. But what is the safeguard we're using? How do we police it?
Maybe he
How
can
do we know that's all he's doing?
I got
Just using it for school.
I got an idea. Maybe the University of Arlington school administer community, I guess that would be their technical people, can make sure that his IP address is only accessing for schoolwork and that he's uploaded. Because like I said,
You get that done, I'll approve it.
okay, so you need to get with your school.
But you gotta give me something so that I can approve it. But see, you made a mistake. You better fix it. But you also have to be careful about not falling backwards on this, because this is very serious. Every image of child pornography is a victimization of a little child. Every image. You know better than that. Don't be getting near this. But you can see how it adversely affects your ability to do things in life.
Yes, it's
Like stay out of prison, get an education. Juries aren't, they see all those images in a trial, they don't have any sympathy for you. That's the history of what goes on in this room in these cases. I mean, you don't have a chance. You got to fix that and fix it quickly and be careful about the decisions you make. Get me something that I can rely on, that we can be confident in.
The state would like to get a copy, Judge, because my initial opinion is I object to him having any internet access.
no, I don't mind.
Yeah, we're gonna have, and I am too, until I can be, unless I can be assured that there's a safety mechanism for at least until we can get this case disposed. Then after that,
Yes, sir. I'll tell him to get with the IT people at this college, and then we'll come back to you and Mr. Ham with what they came up with.
just get it. Yeah, get it. He doesn't have to be here. Just
Okay, just get it sent.
Yes, sir.
That's no problem.
All right. Next event.
Thank you, Judge.
Next event is what?
Just another. Give me.
It was set for an announcement. We'll do another announcement in
About 4 or 5 weeks.
6.
6 weeks, perfect.
Gotcha.
6
Okay.
weeks.
Thanks. Okay. Get a resetting.
Thank you.
Donna Arnold.
I don't see Mr. Kimball.
That's who's. I'm not. Sorry, we can't go on without the. You haven't seen it today. Okay. Sorry. I mean, I've got looks like 3 cases. Did we get anything from Mr. Kimler about him being late, that we're waiting on him? Okay. Ronald Cameron.
Good morning, Judge.
Yes.
Back in 2021, so.
Is that him?
Yes.
What are we doing?
Come back from his lawyers with times and
It's a DWI form.
Yes, Judge, he has some things that he'd like to wrap up here before we enter
How much time?
2 or 3 weeks.
Is that gonna be enough? 2 or 3?
3 preferably, but if it needs to be 2, then 2 is us.
3, you take care of everything in 3 sentences? Yes, sir. Is 3 gonna be good for you? Okay, that gives you a little bit of time. Okay, good. All right. Please get a reset. Thank you. Alvin Lawrence.
He is here. Sign on the X form, please. She's an initial, I just received an offer this morning, and I'm still working with the media myself, but I'm gonna have 4 weeks on him.
Come forward.
Yes.
And now call 25 CR 852 Alvin Lawrence. That's you, sir.
Yes, sir.
And you were here with Miss Minaldi. You're filling out, what is that, an indigent form?
That's correct.
You're not employed anyway? When was the last time you were employed?
At Express 23rd in Washington.
When?
Last week.
Will they fire you?
No, it's like a advanced staff. They help you get jobs and they set you up for things that call you. And then you go ahead and get everything out the way.
So when was the last time you had employment? Is what I'm asking.
Last week I ended up getting paid that Friday.
I believe it's a temp agency, Judge, where there's.
That's what you've been working, temporary jobs for a while?
But I think they are at Texas for twice.
Okay, you're charged with the 3rd-degree felony of assault on a family member of somebody by choking. And this complainant here in this case, how are you related to this person?
Our twin, that's
The one who's in the indictment, Rashona.
those girlfriend.
Okay,
So we have a place to go.
sir.
We have a place to go.
Okay. As you know, you're charged with a very serious offense here. You're choking somebody. And everyone knows when you put your hands around somebody's neck and squeezes, there's only one intent, and that's not to let them go. It's to hurt them or worse. That's why it's a 3rd-degree felony. So you're looking at up to 10 years in prison. You understand? You understand? You can't have any contact with that lady. Do you understand?
Yes, sir.
I find out you do during the course of this until I prove otherwise. You'll sit it out in jail until we can get this moved one way or the other. But we're not going to have something bad happen a second time on the court's watch. Do you understand? So you can't have any contact with her. And that's a condition of bond in all cases where someone is charged with a crime where there is a victim. That's a human versus an entity. So be careful about that. So I wouldn't hesitate, and there would be no option. You would go in jail until this thing worked its way into disposition, which could take a while. It could be quick. I don't know. Okay, it was an initial appearance. We want to set it for an announcement. How long?
4 weeks.
4 weeks. Good. Anything else? Good. Just get a reset. Thanks to you. Austin LaFleur is next.
He's a dismissal judge.
He's a dismissal.
He is. He has a companion misdemeanor that he will plead to today. Once that is done, Mr. Board has expressed that he'll send over the dismissal paperwork for the call.
Oh, that's in another court?
Yes, that's right. Yep.
Okay. You need that on Austin LaFleur. I think this case is going to be dismissed, 24 CR 711, conditioned upon the disposition of a case that's pending in another
And we're
court
going to do
today.
next board meeting.
Yeah, okay. Yeah, okay. And so that'll be done this morning. Okay,
Yes.
great. Thank you. All right. Just let us pass the paperwork to us so we can get that done. Zachary Poole. 23 CR 1044. Got another indigent?
Graciela Lopez. Yes. Good morning, Troy.
Good morning, Your Honor. Thank you, Annette.
This is case number 25CR42478, State of Ohio versus Brasilia Lopez. Ms. Lopez is present with her counsel, Chloe Kirby. The state is represented by Brian Goodyear. Madam Interpreter, for the record, would you identify yourself?
Good morning, Your Honor. Roxana Hazlett, Supreme Court of Ohio Certified Interpreter Spanish.
Thank you. I have a document which indicates that there's a plea agreement indicating that Ms. Lopez plans to plead guilty. That would be to count one, aggravated burglary. That carries a maximum prison term of 11 to 16 and a half years. A maximum fine of $20,000. Prison is mandatory. Also, related to count one, there's a firearm specification that carries a maximum term of 3 years in prison. That too is mandatory. That means that the lowest sentence that could be imposed in this case is 6 to 9 years. Have I stated that, and the state's dismissing count 2 and the firearm specification to count 2. Mr. Goodyear, have I stated that correctly?
Judge, that is the plea. I think the minimum possible sentence, because you don't include the firearm specification in calculating the time on reg and tokes, I think the minimum possible sentence would be 6 to 7.5 years.
It's the felony one is minimum of 3 to 4.5, or the maximum would be
11 to 16.
To 16.
Yes, sir.
So what did I say?
So you said that the minimum she could get on the charge, the least you could give her is 6 to 9. It'd be 6 to 7.5 is all it was.
I was confusing minimum and
Yes, sir.
maximum.
Yes, sir. But Judge, you have stated the plea agreement correctly. That is what we're agreeing to do. Thank you.
Okay, thank you. Ms. Kirby, is that correct?
Yes, Your Honor, thank you.
Okay. Ms. Lopez, I want to make sure you understand what you're doing today. If you plead guilty to these charges, the minimum sentence that you could get is 6 years. And that would include an extra year and a half that they could keep you in prison after your, if you got to the 6 and you had some conduct issues, they could add a year and a half to that term. I'll read that to you in a moment to make sure it's clear, but I want to make sure you understand that that's what you're doing. You have to answer out loud.
Okay.
All right. Has anyone made any promise to you that you would receive something different?
No.
Okay, how old are you?
26.
26.
How far did you go in school?
¿Hasta qué grado llegó en la escuela?
Secundaria.
¿Qué grado?
No sé qué grado es aquí.
I don't know what grade you would consider here. I went to high school in Mexico.
Did she graduate high school?
¿Se graduó de la secundaria? Yes.
Okay. Have you had enough time to speak with your attorney about this matter?
¿Ha tenido usted suficiente tiempo para hablar con su abogado sobre su caso?
Sí.
Yes.
I want to make sure that the record's clear,
Quiero cerciorarme que el acta esté clara,
that you're aware of your rights.
que usted sabe sus derechos.
You have a right to
Tiene el
have a
derecho
trial.
de haberse ido a juicio.
You can have a trial before a
O
judge
tiene tener un juicio frente al juez
or a jury of 12
o
people.
por un jurado de 12 personas.
If we have a jury trial,
Si tenemos un juicio por jurado,
every single person on that jury,
cada
which
una
would
de
be
esas
12 people,
personas en el jurado, que serían 12,
would have to agree that you had been
tendrían que
proven
haber
guilty
estado de acuerdo unánimemente de su culpabilidad,
beyond a reasonable doubt
más allá de una duda razonable,
before you could be convicted.
antes de que la pudieran encontrar culpable.
Do you understand that?
¿Entiende usted?
Sí.
Yes.
You have a right to confront
tiene
every
derecho
witness who testifies
De
against you at
confrontar
trial.
a todos los testigos que vengan a testiguar en su contra.
What that means
Lo que
is
eso
your
quiere decir
attorney
es que
can
su abogado
question the
le
people
hubiera
who
hecho
testify
preguntas a las personas que llegaran a testiguar
for the purpose of
con el propósito
challenging their credibility
a sacarles a ellos algo a su favor
or to reveal anything that might be favorable to you.
o de llegar a lograr algo que la pueda ayudar a usted.
Do you understand that?
¿Entiende usted?
Sí.
Yes.
You have a right to have witnesses ordered
Tiene
to
el
appear
derecho de traer a testigos, ordenarles que se presenten
and testify your
y
request.
que atestiguaran a su favor.
Do you understand that?
¿Entiende usted?
Sí.
Yes.
You have the right against self-incrimination.
Tiene el derecho de no culparse a usted mismo.
That means you cannot be required to
Incriminarse.
testify.
Lo que quiere decir que no le podrían haber obligado a que usted atestigue.
It also means you don't have to prove anything.
También quiere decir que usted no tenía nada que probar.
The state has the burden of proving the case against
El
you,
Estado es el que tenía la responsabilidad de probar la culpable en el caso en su contra.
You do not have to offer evidence.
Usted no tendría que ofrecer pruebas
You do not have to testify.
y no tendría que haber testiguado.
If it's a jury trial
Si fuera un juicio por jurado
and you do not testify,
y usted no atestigua,
I will instruct the jury.
yo le hubiera instruido al jurado
They cannot consider the fact that you
que no
didn't
pueden
testify,
considerar el hecho de que usted no quiso testiguar
and they could not discuss it during their
y no lo
deliberations.
podrían discutir entre ellos cuando están deliberando.
If it's a trial to a judge,
Si es un juicio por juez,
I would not consider the fact that you had
yo no
not
podría
testified
considerar el hecho de que usted no quisiera testiguar
and would not hold it against you in any way. Do you
y no lo
understand that?
mantendría en su contra de ninguna manera. ¿Entiende usted?
Sí.
Yes.
Do you have any questions about your constitutional rights?
¿Tiene usted alguna pregunta sobre sus derechos constitucionales?
No.
No.
Okay, we're going to move to the next item
Vamos
here.
a pasar a la siguiente paso.
That's called post-release control,
Se llama libertad después de la prisión.
which is supervision by the Adult Parole Authority.
Supervisión del Departamento de Probatoria.
So once you've completed the minimum part of your sentence,
Cuando usted ya hubiera cumplido la sentencia, lo mínimo de su sentencia,
the Adult Parole Authority
el Departamento de Libertad.
Your office has filed a nollie. Unfortunately, it was filed last week when I was gone.
Okay.
So I just want to make a record. Do you have anything else? It looks like it's signed by Teresa.
No, I have nothing additional here.
All right, the court will grant the nollie. And his file date is September 11th, 2023. This is case number 25CR42913, the state of Ohio versus Mark Crow. Mr. Crow is before the court with his counsel, Mr. Kidd. Ms. Nicholson, on behalf of the state of Ohio. Ms. Nicholson.
Your Honor, it's my understanding the defendant will be entering a guilty plea to count one. The state will be dismissing count 2, and we'll be asking the court to order a pre-sentence investigation.
All right, Mr. Kidd, is that accurate?
It is, Your Honor.
Okay, Mr. Crow, they're telling me you're going to change your plea to one count of the indictment. Before we get to your change of plea, I'm required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
I'm 52. Be 52 tomorrow.
How far did you go in school?
12th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, I understand the.
Okay, has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Kidd?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on?
No, sir.
I have in front of me a document. It's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney?
Yes.
And you believe you understand what it says?
Yes, sir, I do.
This document says you're entering a plea of guilty to one count of aggravated possession of drugs as a felony of the 3rd degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. Do you understand the maximum penalty involved?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means that if you are sent to prison on this charge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on TRC, whichever is longer. That time would run consecutive to any additional prison time that you are sentenced to. Do you understand that?
Yes.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of Mr. Kidd, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
Now, you could waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir, I do.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
I understand.
This
Yes.
is how you want to proceed.
Yes, sir.
Ms. Nicholson.
Your Honor, if this would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about July 31st, 2025, in the city of Lebanon, Warren County, Ohio, the defendant was stopped by Lebanon PD, who knew he had an outstanding warrant. A search incident to arrest was conducted, and suspected methamphetamine was located in the defendant's right pants pocket. It was determined to be 14.65 grams of methamphetamine, a Schedule II controlled substance, and the defendant told police that it was ice.
Mr. Kidd, anything on those facts?
No, Your Honor.
Mr. Crow, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said is true?
Yes, it's true.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we discussed.
I understand. Yes.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, Mr. Crowe. We'll come back in a few weeks and do sentencing at that time. All right, thank you.
Thank you, Your Honor.
Just filling something out. You don't have a job?
Yes, sir.
Okay, you're filling out, what is that, an indigent
So
form?
he was here previously, with
I expect people
wanting
to
to
pay for their.
hire an attorney, but then he was unable to hire an attorney. And the court staff let me know that he did not have a new indigent form on file. So I was just getting one for his file because they like have an updated one.
Okay, so what are you doing about hiring somebody? Are you able to hire somebody?
No, sir, no, it's not.
Why not?
Because the lowest offer got was 10,000.
The lowest offer
Yes, sir.
for burglary of a building, a state jail felony?
Yes, sir.
I believe he's
You
talking
might go
about.
with, you might want to go to someone else. That sounds a little high.
Where's your
Good.
How many people did you talk to? One?
No, sir, it's over 10 people.
How many?
10.
Right, that's
And the lowest offer is 10 grand for for helping you on a state jail felony?
Yes, sir. Actually, I think the lowest was 75. Yes, sir.
Do you have any prior convictions? And this is their first offense?
Yes, sir.
Color me amazed. That doesn't sound realistic at all. I know what's going on out there, but that's not realistic. She knows what the temperature of the business is out there, but first offense without any prior convictions on something like that, unless it's going to be taken to trial. I mean, if somebody's insisting on a trial, which is what you have a right for, then that might be different. But these are kinds of things that generally don't get worked out. Don't work out that way. They work out in a pretty quick disposition. If you've never been in trouble before, there's a way of making a mistake and then getting it fixed without a conviction.
Yes, sir.
Is there any loss here?
Yes,
there damage and
there's
loss? Is there a lot of things? Is there a lot? Oh.
We have offers in both cases. I just have not had a good contact number for Mr. Poole. He's going to call.
Does he have one now?
I have one now. We have potential resolutions in space. I could just have 4 weeks to talk with him about that and try to get something moving in one direction or the other. I believe this would be a resolution, Judge.
It would make sense. It's just hard to believe that's the temperature of the cost for something like this under these circumstances. There must be something else. I don't know.
There are two cases, Judge. He has two different offenses. And there is restitution in both cases. We have relayed the offers to Ms. Finaldi.
What were the, there's 14,000 on this one, it looks like.
The other one is around 5,800, Your Honor.
Well, where's the stuff? Was that returned? Is that returnable?
I believe some of it was sent to the scrapyard and then taken off, so I don't believe that they're.
Is there anything returnable?
I think it would have to be in the form of tracking, rest of it as reimbursement instead of. We're working on it.
Well, that adds to the cost of everything. What does this tell you? All of this mess that you're in. What did you learn?
Yes, ma'am.
If anything, I'm hoping you learned something.
Not sure some people.
It's somebody else's fault?
No, there's not. Well,
Okay. All right, that's where it first starts, is
Yes, sir.
taking responsibility and fixing it and not being induced to make bad choices by others. But most importantly, at the end of the day, it's your choice, unless they put a gun to your head.
Yes.
But what is it about thou shalt not steal that you don't understand? You've heard that one before, haven't you?
Yes. Yes.
Let me ask you, do you believe in that?
Yes.
Oh, okay. Act as though you do
Yes.
in your actions. Oh. Makes it simple. This is fixable.
Yes.
Just fix it. Okay, and follow this lady's advice. It's smart.
Yes.
All right, so
4 weeks, Judge.
you got it.
Thank you. Thank you, Judge.
Both cases reset. And
Bill this out. And she's.
Cameron Smith, please. Cameron Smith,
Yeah.
25 CR 860, Cameron Smith. This is a initial appearance.
That's correct, Judge.
Okay. You are charged with the third-degree felony of collision involving an injury which carries with it up to 10 years in prison. Serious. Oh, I see what we did. This, we just tried this case. We just tried a case like this about a month ago. And there's the defense lawyer there.
That involved death. This involves injury.
Yeah, well, it's gotta be serious though, right? See.
But does not require serious bodily injury for this offense, Judge.
Yeah, but when you're the way the law is written, when you're involved in an accident, whether it's your fault or not, if you're involved in an accident, you have a duty to remain at the scene and help any injured person. That's the duty. It's a very selfless law. It was unusually written to help your fellow man. It's a very benevolent law. But anyway, you pay a price and you're looking at up to 10 years in prison. So what do we do today?
Judge, this is a initial setting. I'm still working for media. If I could have a reset for the whole week.
Yeah, okay.
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 Thank you, Judge.
Thanks. Nathan Davis, James,
We just
Nathan.
signed up and sent some paperwork to you for a plea, Judge.
Okay. And
Thank you, Judge.
where's, thank you, man. Hey, there's I'm like, Mr. Pad. Okay, 25 CR 182 is called the State of Texas versus Nathan Davis.
Yes, sir.
You, with Mr. Paget, the attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here?
Yes, Your
Are
Honor.
we proceeding Sunday?
Yes, Your Honor, we can.
All right, and you're still in LaPorte?
No, sir.
Oh, well, I'm gonna update your address here. Stand by, hold on. Mute some. Okay.
Present before the court is Mr. Hernandez, right?
Yep.
And we have Mr. View from the prosecutor's office. We are here today on the application to seal the record filed by Mr. Hernandez. And the court is in receipt of the report of probation. Mr. Hernandez, you have a copy of that, right?
No. That's the form I gave. Yeah, right here.
Okay. And it indicates that it looks like back in May of 24, Mr. Hernandez was granted ILC. July of 25, he successfully completed intervention in lieu of conviction. Mr. View, anything from the state?
No, Your Honor, looks like his case was dismissed and he's eligible to have it sealed.
Is there anything that you would like to tell me, Mr. Hernandez?
I want to clean out this because I want to keep going with my life with it more easy, you know what I mean?
Okay, I am going to grant the request to seal your record. Let me make sure, Mr. Hernandez, that we have an email address for you. Is it jose.gomez?
Yes, sir.
Some numbers at gmail.com, right?
Yeah.
All right. So once this entry gets processed, you're going to receive a copy of this entry via email. Make sure that you hold on to it because we're going to seal the record. So it's not like you can come down to the clerk of court's office and pick up a copy.
Oh, okay.
Okay?
All right.
All right. Good luck to you, sir.
All right. Thank you very much. That's it.
That's it.
All right. Yeah.
Yeah, well, it's not.
Well, maybe they have patch issues, so
I haven't.
I didn't
I
know if
haven't.
you,
Hold on. I've got one case of Donna.
she has three.
Three cases. Sorry.
I just didn't know if you wanted maybe to have her tested just because that's what the issue is. She's
Well, I'm a lawyer ought to be here to be helping advise her.
Yes,
That's the
That's right.
sad thing about this, which happens all too often under these circumstances, I'm afraid. Oh, so you have a drug patch right now? Okay. There was one collected in August 6th last month. And it showed positive for methamphetamine. Then there's another one before that was collected in July that showed positive for amphetamine and methamphetamine. Then there was one before that in June, one before that in May, one before that in April. This is consistent. You're testing positive for methamphetamine. I've got 1, 2, 3, 4, 5 positives in a row for successive months. We got a problem.
You sure?
Sir, I didn't know.
You knew.
I want to forget.
Well, who forced the methamphetamine in your system without you knowing it?
I wasn't friends, but I had stopped her. That after I came here and I felt that drug test,
Man, well, hold on. Nobody's told you all your drug patches are showing up bad?
no.
Well, you just don't. Look, methamphetamine comes in and out of the system pretty quickly. You've got 6 months worth of steady methamphetamine positives. You got a problem. Yeah, get her tested. I'm gonna get her tested right now first, but you got a problem that we got to deal with. And because something, I mean, with this knowledge, I can't just let you saunter on out of here.
Thank you, Judge.
And then get in a car and something bad happens or something is something irresponsible because of drug usage that is showing up that we're all seeing. This is not one red flag. I see 6 red flags. You got to fix this. If you can't, I'm going to help you do it, but we're going to work on it. But you're obviously having a problem making the right decision when it comes to serious drug usage. So,
You want him very much?
yeah, she's going to get tested. I mean, could you, would you be so kind just to tell the jury we're going to need about 10 more minutes and ask them to thank them for their patience, please? Thank you, sir. Of course, her attorney's not here, so that's
Yes, sure.
that's too, that's again another issue.
Yes.
But I
know your tendency, and I want to point that out to you.
Yes. Well, it's unusual, and there's a consistent pattern, and what happens is later you see 5 or 6 consistent drug failures on drug patches, and something bad happens, then the headline on the news should say, "Who's to blame?" And there's some blameworthiness with the person who's using the drugs, but who's policing this? She's on our watch, and she has an attorney who should be present on something this serious who's not here. And that's
just her record.
okay. No, well, we're going to help her and help the community be a safer place. That's the whole master plan.
The way that I am in trial and I did not work that in.
What do you think? Oh, they're saying this. He's a boss.
You better bring it.
They had asked for those recertification records going back. We have produced them, which prompted her to ask a series of questions, which our client is researching the answers to.
Got it.
I don't know, but of course, this is a case worth trying to work out. And Ms. McFarland suffered another loss in her family. And so I don't want to do a trial with her while she's grieving.
Understood.
So if we could set it out maybe a month and hope against hope that we can actually resolve it without your help.
Okay. October 14th, 2025, 9 a.m.
Thank you.
All right. Thank you, sir. New Park Ridge Apartments versus Tubbs.
James Singh for the plaintiff. I thought she was going to come and give us evidence that Mr. Gardner's bonus had changed, which would launch us into some kind of discussion of a COP. I could do a couple of things here if you want to give her more time to show up.
Okay.
But
we can do. We can do that.
And I'll check the sex offender registry addresses while we're waiting.
Okay, all right, then I'll pass this time. Barnes and Barnes versus Ariel Daniel. Did they check in?
They did not.
Ariel Daniel or Jason, or I'm sorry, yes, Bruner Kemper. It's a lot of words. Bruner Kemper.
If you recall, they had moved.
Yes.
And then they were disputing the charges. You said for today.
Right.
I have talked with Jessica, the manager, the charges that I've seen ledger, they are what they are.
All right.
And 20 rent 275 off for 3095. But
all right. I'll do it this way because and we're sure that possession's been surrendered.
Yes.
Oh, okay. Then I will at this time then enter the money judgment for the amount paid for 3095 on this case. And I'll do that by default. All right. Thank you, sir.
Is your own part when you said one?
You'll need to send one in. All right. Okay. Thank you. Beal Properties versus Jason Mitchell. Is this Mr. Lloyd?
Oh, they work. Yeah, this is Miss Lacy and Mr. Lloyd.
So somebody showed up for Libby.
Yes, Miss Lacy is here. You can see Mr. Lloyd.
So Lacey and Lloyd are like in a room talking.
No, Mr. Lloyd's in the hallway. I can see his backside. Don't see Miss Lacy.
Yeah, that'd be a conversation. No, I don't want to. Court calls the estate of Earl Samuels versus Jonathan Samuels. Good morning, sir. Your name, sir? All right. This is in effect, and just so that we're clear on the record, it would be effectively a hearing to determine whether or not a order of eviction should be entered, but that had been entered. So I'm hearing your objections and whether or not I should let that stand, sir.
Yes, Your Honor. Because it was not obtained according to proper procedure in multiple ways. If it is appropriate for Attorney Marcus as the acting for the personal representative, if it is appropriate for him to use the landlord to obtain the order of eviction, he didn't follow the requirements of the law the way, because he just tried to continue a case from nearly 2 years ago that wasn't at all the same legal entity, even though they inappropriately called it the state of Earl Samuels 2 years ago. It was actually, Dad was alive, on sale, now Dad died and there actually is an estate. So to come to the court as Attorney Marcus did last month and say that he's now the representative of the entity that obtained the order, the judgment or the court, conclusion 2 years ago. No,
but sir, you need to understand that there are numerous occasions where there's a judgment entered by a person being or a live person who subsequently passes away. That case is then basically renamed with their estate. And it happens from both sides, particularly in with landlord tenant. It can happen from the plaintiff side, it can happen from the defense side. So I don't know that that's necessarily an issue for.
Well, it is because now I'm a 50% heir, so I have a totally different legal standing than I did initially. So, and under the law, I have.
Yes, but that your standing vis-a-vis that property would have been taken care of by the probate court.
Well, that's part of my argument is the probate court should be handling this.
No, they don't. They don't have to. As to the possession of premises, there is actually, in one reading, there's either I have jurisdiction over it or there's concurrent jurisdiction between the probate court and this court. So either of the courts can act.
I thought it was pretty narrow, the landlord tenant law saying that the ER in a case like this can only act to evict after the property, it says conveyed, says it's 600-5407-1H. Where it's narrow in what it allows the district court to do, because
the district court can act where a personal representative is properly before the court, but the authority for the personal representative to act has to come from the probate court. I can't confer their authority to act.
Well, the bottom line is that Attorney Magnus was obligated to do things in a more deliberate way rather than just try to use something from nearly 2 years ago. And you're saying that sometimes a ruling for before that can be continued on, but I would argue that because I'm a 50% heir that.
But you would have had to have gone to the probate court, right? Because the very fact that you're an heir to the property doesn't matter. What matters is that because there's going to be somebody that's going to be able to act regarding that property. And that's going to be the estate. And whoever is the personal representative of the estate is going to make those decisions, despite your status as heir. If you have an objection to what they're doing, then you go to the probate court, you make your objection to the probate court to what they're doing.
And I am, and I'm in the middle of that, and there's appellate cases that relate to this. So there's many things going on that Attorney Magnus tried to go around that to involve this court by saying that he was continuing something from 2 years ago, which is significantly more complicated than he.
Did you seek a stay at the probate court to this court's action?
I filed a couple motions for reconsideration. I'm filing.
And the motions for reconsideration is because the probate court has ruled against you.
Right, because Attorney Magnus said things at the hearing that were not true, and the judge didn't have an opportunity to hear.
Which judge was this?
The new Oakland County Probate Court Judge Tracy Richards, who placed.
So Mr. Magnus went in, said what he said with his magic words, and just fooled the judge.
Well, she was giving deference to Attorney Magnus and my sister's attorney. You
are not going to. One thing that you're not going to do I don't know, Judge Richards, I don't know. But I will say this, if you are, courts give deference to parties when they come in, all right? If you are going to indicate that a colleague of mine on the bench, despite being in another county, has shown some bias to your detriment, if you're going to make that argument here, the only thing I'm going to tell you is you better bring it. Because if you're going to make that accusation, you better bring it.
Well, the judge was proceeding as though Attorney Magdas and the attorney for my sister would be obligated to tell the truth. And she assumed that when she asked them direct questions that they wouldn't say things that there's material facts that contradict. So that's all parts of my motions for reconsideration because there are.
Has she ruled on your motion for reconsideration? Has she ruled on your motion for reconsideration? Okay, so you want this court to, so why didn't your motion for reconsideration include a stay of these proceedings?
It referred to these proceedings.
That's fine. Why didn't it include the request for a stay of these proceedings and or a request to prevent the personal representative from doing specific things until such time as the judge could consider?
I asked for multiple things in the motion for reconsideration. I don't think I used the specific language to ask for a stay of this proceeding, but I'm actually, it's 2 weeks today from the hearing.
So, sir, let me explain something to you because built in when I was a bit shocked when the parties appeared the last time by a number of things. One of the things that I was a bit shocked about was that you did not reside in the premises. And let me tell you why that's important. Because once the court determined what it determined here, that there had been a hiccup in trying to figure that out, the great fear for the court is that somebody was displaced from the premises to their house and that something that happened shouldn't have happened. That harm isn't really in existence here at this time. You couldn't have resided at the premises because our order of evictions have a procedure in place that allows you to get before this court prior to the execution of any writ or order of eviction. And that is basically a 72-hour hold after the posting. That's the first thing. The second thing is that, from my understanding, there haven't been anything removed from the premises.
Well, but there was harm. They removed 2 vehicles which had value, and I really need the money from those vehicles. So.
Okay, so if you believe.
That's part of the eviction.
So, okay, so if you believe that the eviction was improper, that you lost some property, then you would have to go after the estate. That doesn't come here.
What I was asking for is just to stay the eviction until we resolve things in the probate court. So
I don't know why I do that.
Because Attorney Magdas didn't follow the procedure in several ways.
I'm giving you your hearing now. And that is precisely my point. Other than these vehicles that you say have left, and I don't know anything about the vehicles, there hasn't been the harm that would normally inure to somebody who has been evicted in this instance, because property hasn't been removed. So I'm able then to give you the hearing as to whether or not to allow the eviction to stand. And in fact, give you, as I indicated at the last hearing, frankly, more time than you would have gotten otherwise to make whatever argument you needed to make to the court.
The argument is that the probate court should control things, and if not, then
if you believe that, sir, and that this court wouldn't have jurisdiction over a property that is venued in the 14A district, if you believe that, then that argument needs to be made to the probate court to stay the eviction or to prevent the personal representative from acting on the eviction.
I'm in the middle of that process.
So if you're in the middle of that process, then I should allow this to stand. And then you argue that before the probate court.
That I think there's reasons to not allow this to stand, because Attorney Magnus didn't go through the proper steps to.
I know Attorney Magnus is just a very bad individual. I get that, but that's not a basis upon which I make my decision.
Well,
I say that.
He's, as personal representative, he's obligated to be impartial, and he's doing things that favor my sister.
He does, I would imagine that he's doing things consistent with his fiduciary obligation to his client, that being the estate, which there are going to be those which are involved in the estate, because it always happens, that aren't going to like that. So the real issue is you don't like what he's done.
Well, from my first conversation with him, I told him that the essential thing was that the farm stay in the family, and he said that he agreed with a basic argument that the person who was trying to buy it 6 months ago didn't have a good case to be able to continue trying to buy it. But then he changed his mind. So, and this eviction then helps him proceed with the sale that he changed his mind about he changed his mind in July. In June, he told me that the person trying to buy the farm from 6 months ago.
Who's the personal representative of the estate?
Timothy Flynn, the person that Attorney Magnus represents.
Yeah. So why do you have so much animus toward this man?
Why does he have such animus towards me? I was living at my parents' place more than half the time.
Apparently I struck a nerve. Are you listening to what you're telling me?
Your Honor, if someone
are you listening what you're telling me? Every sentence has begun with his name. He's an attorney representing a personal representative of an estate.
Yes, and he's obligated to be impartial, and
he's obligated to do his job for his client.
And
that's his obligation.
And that would potentially include me. I was the one who worked to create much of the wealth that still remains in the estate. It was my sacrifice for many years. So for him, he's doing things which will diminish the wealth of the estate.
And why would he do that?
Because it's quicker. He's doing things that will resolve the estate more quickly, which is what my sister's attorney wants, rather than to achieve. I mean, for example, my parents' house is not in great condition on the outside, and I have things prepared to do work to achieve closer to full market value. But Attorney Magnus doesn't want to do any repairs and just wants to prepare it for sale as quickly as possible. So he's gonna sell it to not a typical buyer, a flipper person who will.
Is he doing that against what the wishes of the personal representative are?
No, he's doing it because that's what the personal representative wants, but it's against. what makes
Exactly.
sense for the-
Exactly. That's his client.
I also have an interest in the estate and.
You do. And if the decision is made that the property is sold, I'm presuming you'll get your fair share.
Yeah, but my fair share of a diminished sale significantly. Imagine the difference between.
Then you have to argue that to the probate court.
Yes, I'm in the middle of arguing many things to the probate court. And
Okay.
You're saying, so a key thing, Attorney Magnus on June 30th changed the locks. And
there we go.
More than
He went out there himself and did it?
What?
Nothing.
He
Go
did
ahead.
it. What?
Nothing. Go ahead.
What?
Go.
Can I reply briefly?
Yeah, no, you've been very good at being quiet, so we'll let that continue a little longer. Go ahead.
So on June 30th, without any notice, without telling me that I shouldn't be staying at my parents' house more than half the time, he came and changed locks. All my things were there. He saw that my food, my computers, my clothes, everything was there, my legal papers. Imagine if someone just came to a residence where a person's living and locked them out. And
But you weren't living there.
I absolutely was living at my parents' house more than half the time. And I had Google Maps timeline showing in 100 and.
It's a different house now. Sorry, Farmington House.
So we're talking about Attorney Marcus's actions, which have been impartial, which I keep referring to him because he has demonstrated, and the way he said at first that he understood how important keeping the firearm in the family was to me and how the legal argument to sell it seemed reasonable. Then he changed his mind without justification. And all of this is the whim of Timothy Fuller and Steve Magdas, rather than what's really right for the value of the estate and respecting what my dad wanted. And people refer to the estate as being intestate. There is a will. The same people who refer to no will.
Can I just say this? All of that, you've got to take me for the probate court. I told you at the first hearing, if I wanted to be a probate judge, I would have been. I'm not dealing with the will.
But
if there is one.
You're going along with what he did.
Okay, yeah. I'm going to tell you what. I don't think I've ever met Attorney Magnus before. I don't think I've ever laid eyes on him before that last hearing. What I saw his appearance, I had no idea who he was. So don't come before this court, because I know where this is headed because of the way that you make your argument, and claim that I, for whatever reason, have some bias or some other interest in what he says to me. He has said nothing in this hearing, and I see huge problems with your argument regarding this writ.
What about problems with the way he obtained the order from you? Because
which I'm going through the process right now of correcting.
I would argue that the way the law is, the order isn't appropriate yet, because like the 600-547 is narrow in what it allows the district court to do as far as evictions. And I think I've cited it correctly.
When you say it's narrow, what do you mean?
Well, that's what I want to refer to is the 600-5407 has just one reference to an estate and a personal representative. And it says after, it says after sale and conveyance. Oh, I have it wrong. 5417. So here, 5714. I had the number one, 600-5714. 1H, when a person continues in possession of premises sold and conveyed by a personal representative under license from the probate court or under authority in the will. So that's when the law that let you sign the eviction order would apply.
No, sir. You need to read the other parts of the statute. That is one instance.
Well, that's the only one that I saw referring to an estate like this.
Okay.
And there is other case law. In fact, there's a case that Timothy Flynn was involved with, the state of Anderson, where they let eviction issues be handled by the probate court.
Sir, what did I say to you earlier?
I mean, you said the probate court, but I'm just asking for you to let the probate court make the decisions until it's clearly justified under 600-5714-1H for you to.
And what I'm telling you is that I'm likely to rule. And then if you believe that I am in error, you can appeal me. Or you can seek a stay of any ruling that I may enter that you deem disadvantageous to you. You can seek a stay from the Oakland County Probate Court.
Yes, Your Honor. But you could also just have a stay to wait for some additional proceedings in the Oakland County Probate Court. That
I could do it that way. But I'm telling you, I'm unlikely to do that.
I'm fighting all this to try to respect what Dad wanted, and if I was ever to leave the family, absolutely. This is all I have plenty of equity in other property to buy the farm. When Attorney Magnus locked me out of the place where I was living, we made life very difficult for the last 9 weeks. So I haven't been able to function very well. I mean, today I rode my bike here 30 miles because I don't currently have a working vehicle, because my life is completely a mess. And Attorney Magnus, by locking me out without notice of the place where I was living on June 30th of this year, did something that most would regard as unlawful. So you're not allowed to just lock someone out of a place that they're legitimately living. Attorney Magnus tries to argue that.
You know what? You coming before me, and you just tried to besmirch this man, and you were about to, if I hadn't cautioned you, take a shot at a colleague of mine on the bench in Oakland County. Why don't you just give me the merits of what it is instead of explaining to me all the bad things everybody in the world seems to be doing to you?
I have the means and assets to accomplish what Dad wanted, and the action.
Can I ask a question? If that's all true, why aren't you making an offer on the property?
I did, and they don't want to accept it because I have to sell my properties first. So, you know, people buy properties all the time where they have to sell their own residence first. So rather than work with me, that's why I'm so upset about everything, because people are not looking at the facts of the things, the equity that I have. It's just a matter, I could sell things as is today and get 280,000 from my West Bloomfield previous residence, or I could do a few things and get 350,000. Or I could do a lot of things and get 450,000. Next door house sold for 450 earlier this year. So people can put on me under how much pressure they want. Do they need me to do something today and sell the West Bloomfield house as is for 280? Or do they want me to get 350 for it so that I'll have more to buy to put towards my offer on the file? And I have other properties with significant equity also, and it's a similar story. So the personal representative, the estate doesn't have to be closed right away. I've made an offer that's higher than the offer that they want to accept. So there's, and it's just what my parents wanted, what I've always said was so essential. So why won't the personal representative or his lawyer work with me? Why did they change their mind? Why is it okay that he locked me out of the Farmington Hills house?
Okay, that's in Farmington Hills.
Yes, and I'm
Welcome to Washtenaw. I don't have anything to do with Farmington Hills.
right. But the one thing that you could do is to not allow this eviction to stand and just to wait for some additional probate court action. Because that's really what controls things, as you said.
Oh, I don't think I said that entirely.
I'm sorry.
Okay, have you finished with your argument?
I mean, there are other cases where probate court was the one that made decisions about landlord-tenant issues where it's not really falling under the landlord-tenant law. Because of my interest in the property, the way as 50% advisee, title will ultimately, if it goes to me, will ultimately be backdated to the day of dad's death. It's like title transfers at the time of death subject to administration. So it's not a typical landlord-tenant case, and there's other case law that supports that. I just haven't had time to prepare things for you.
As I said, you've been given way more time than most individuals coming before this court.
Considering that I'm struggling with the probate court, so many filings, and the appellate court, and my unstable living situation, I would argue that I could be given a little more time.
Anything else?
Just think that the court is letting, as with so many things that happen with probate court involvement, the lawyers have sort of gone around the rules, and it's.
So now you're accusing the lawyers of going around the rules and the court's letting them.
Well, by signing the order of eviction, when it really had.
Okay, well, let's get this clear. Signed the order of eviction, stayed it, had a hearing, gave you additional time once I found out that it really wasn't a residence and things hadn't been removed, and now we're here today. So if you want to talk procedurally, while it is unusual, if you want to talk procedurally and any detriment to you in that, it's not there.
Well, I have been harmed by the removal of my vehicles. And that was a part of the eviction proceeding. He removed the vehicles. The eviction server person required that the vehicles be towed before he would do his eviction and break into the house. And they did take things out of the house and damage some things. And I haven't analyzed what they damaged because I had been living there.
Well, before you told me they had.
What?
Before you told me they had.
I never said they hadn't damaged the house. They broke into the house and threw a bunch of things out on the lawn, and I put some things back on the porch. But they had.
Is there anything else you want to argue to this court?
I mean, there has been harm, and the harm came after they misrepresented to the court that they were entitled, that the PR and his lawyer were entitled to have the order of eviction signed by.
Sir, there's a big difference between doing something and misrepresenting something. And, you know, I'll be honest with you, I'll listen to you but I'm not going to allow you to just come in here and just smear everybody that seems to come in your path. Because that's all that you're doing. People are going to disagree, sir. Part of the reason we're here is because people disagree. And I have to make a decision, but it has nothing to do with anybody personally. For me, it doesn't have to do with any of that.
But the actions of Attorney Magnus did have very real consequences for me over the last several months since his involvement. I mean, mainly with the Farmington Hills house and with his changing his mind about the sale of the farm and trying to get the farm sold rather than have me be able to buy it. So he has made arbitrary decisions, him and Timothy Flynn, which have
they can be as arbitrary as they want. As client, they can be as arbitrary as they want.
I would argue not. I would argue that the law.
Oh, okay. You can argue that. I'm telling you, they can be arbitrary regarding certain things that they want to do. They don't have to operate on your moral guidelines.
Well, the law is very clear that they're supposed to be impartial and not do things that benefit the favor of one devicee over another.
Then that you need to take up with the probate court if you believe that that's happened.
I absolutely believe it's happening, and I absolutely am taking it up, and that's part of
then that's where that argument belongs.
That's part of the reason I need more time here, because all of this helps to speed along what should have been more deliberately handled in the probate court.
Anything else?
What remedy is there for the harm that's been done by Attorney Magnus having my vehicles towed and that was only because of the August 21st order that you signed when Attorney Magnus implied that he was continuing, we've discussed. What remedy is there for the harm that I suffered? And there is a harm to the.
What kind of vehicles were these?
It's a 2002 Pontiac Grand Prix that was functional and needed a new fuel line. That's
A 2002 Pontiac Grand Prix.
yeah, I mean, it's not worth much.
The other car, what's the other vehicle?
I've submitted pictures, Your Honor, of the vehicles when we killed them.
The other car is a 1990 Honda Civic, which is actually worth more than the Grand Prix, even though it's not functional.
Yeah, that's people judging what American cars are worth. Go ahead.
Well, it's because there's some like people, fans of a movie, people like this old model Honda hatchback, and the engine in my Honda Civic has only 100,000 miles on it, and there's other parts. So I've seen ones that are just like a shell for 1,000 or more. So my car with significant parts was worth over $1,000, the Civic. And
okay, so it's $1,000. And then how much is the other one worth? It's a GM, so it's not much. I'm a Ford guy.
The other one was worth between $500 and $750, whereas scrap value.
So we're talking $1,500.
I would say the Civic is actually worth more than 1,000. I said 1,000 for a.
How much are you saying?
$2,000.
2,000 total. All right. Anything else?
Briefly, Your Honor,
You may take whatever time you want. You have been very patient and listening. Go ahead.
I won't take long. You and I think see the same case the exact same way. I'll just say we're the latest in a long line of judges and attorneys engaged with Mr. Samuels in the exact same way. We have, I think, 7 other eviction cases. There's 9 appeals, maybe 10, I think, Court of Appeals with regard to, this goes back many years. The point being, I did put the court in this position by missing that 56-day court rule.
And can I just stop you there? Because, and I think it's important to point out, as this gentleman has been sort of smearing you, one of the things, and I remarked it to my staff when I went back, and that is that you came in, and for somebody that's looking to hide stuff or do whatever, the shady stuff he says you're doing, you stood before this court, said, look, Judge, I wasn't aware of this. I did this. This is what I did. Just straight up. And I'm going to just tell you this, Judge, I appreciated that. That's how lawyers practice. Go ahead, sir.
Thank you. Yeah, so like I said, at the last hearing, I learned that one in real time, right? So we could have had this hearing 2 weeks earlier. But as you said, the result's the same. Mr. Samuels doesn't live there. We removed his cars. Yes, they're waiting at the impound for him to pick up. No problem. And I just asked the court issue the order so we can move this whole process forward.
All right.
Yeah, they want a lot of money to pick them up. So that's, and it's, I have another property a mile away that if he worked with me, we could have put my cars at my other property a mile away. Now they're somewhere 20 miles away and it's.
Or if they were drivable prior to this happening, you could have moved them
Yeah, they weren't drivable.
Okay, then you could have gotten a tow and got them there.
Exactly. A mile would have been an easy, cheap tow, but Attorney Magus didn't work with me, didn't contact me.
You know, I just hook into my truck and drag it up. I'm kidding. Go ahead.
Well, no, I actually could have done that to take him down.
So why is that his fault?
Because he didn't let me know that he was.
Because everything is his fault.
There was no reason for me to think that he was towing the cars in August.
Okay.
There was no reason for him to have done that without notifying me. He gave me no notification at all. And he was notifying me of other things. He refers to evictions and all. The bottom line is that when I was conservator, I did for my family what anyone would want a conservator to do. And I was only removed as conservator 2.5 years ago because other attorneys said things in court, material facts that are absolutely not true, that the judge even acknowledged when seeing video.
Oh, so these were other lawyers that lied?
No, it's again, my sister's lawyer is the main.
Oh, okay. All right. I'm just trying to get it clear.
Well, my sister's lawyer has misrepresented material facts many times.
Okay. There we go again.
She has.
Okay.
Can prove.
Okay, that's fine. Is that before me?
Attorney,
Is it before me? Is it before me?
In a way, it is.
Why is it before me?
Consequences of it are before you. All of this has happened because from the beginning, I did what anyone would want as conservator. And instead of it being applauded, I markedly increased my parents' wealth. I did everything the way Dad wanted. I cleaned up their house to such that the judge, seeing the video, said, yes, it does look good. But the attorneys for other sides said, I didn't do what I did, even though they had video, proof, and later acknowledged that I did what I said I'd done, but they hadn't believed me. So it is before you because the consequences of everything that's gone on in the last 4 years lead us to where we are. So this is just the final action in a terrible sequence of events, which started with my sister betraying my parents when they were clear on what they wanted for the future. And both my parents died prematurely without me caring for them because of the probate court involved. And it's obviously sounds crazy, but it is.
No, it just sounds like another one of your attacks on somebody else. That's what it sounds like to me.
So when Dad was saying he wanted me to keep caring for him and I was having him gain weight and they took him away from me, it's my.
Sir, then all of that has nothing to do with this case.
Indirectly, it does because it led us to where we are. It's like there should be, my dad's will said the PR would be my sister and me. We only have an independent PR because of actions by my sister's lawyer 2.5 years ago that I didn't even understand.
Then you need to bring that to the probate court. I can't do anything about that. Even if, for whatever reason, I thought you were right, and I have my serious doubts as to whether or not you are. Even if I had my doubts, there's nothing I can do.
Well, you could just do nothing rather than enter the order of eviction.
You haven't been here before. It's rare I do nothing.
Well, in a case where there's some question as to.
No, I really don't have a question.
There are some appellate cases relating to the district court's involvement in the estates and landlord tenant issue.
If you believe that my action is inappropriate, sir, you have all of your appellate rights.
I'm already completely overwhelmed with what I'm trying to do.
Whether or not you choose to exercise those rights is beyond me, but you will have them. And unless there's anything else, I'm ready to rule.
I understand that, and I just think that you're, as with everyone, respecting the lawyers instead of analyzing actions that they've done. Like,
sir, you know what? I'm going to stand in here at recess. I will come back. I promise you I will come back, but I don't want to say anything that's going to get me in a whole bunch of trouble.
All rise.
Ms. Ridley.
Help me here.
You see.
please try to understand.
All right. Oh, I do understand. And I've listened to almost 45 minutes of your argument. And at each point, frankly, and just to surmise that you were always blaming somebody else for doing something to you and then attributing some evil motive to why they were doing it. And it's all because things didn't go in your direction. In this case, counsel freely admitted that there was a violation of the 56-day rule. However, this court determined that there really was no harm that inured to the defendant because of that. And the reasons for that are, number one, the defendant did not reside in the address. Number two, property was not removed prior to the defendant filing what I'll call his motion before this court so that he could be heard, with the exception of 2 vehicles. It's also come out during the course of this hearing that despite that, defendant had access to those vehicles in the sense that he could have paid for those vehicles and retrieved them, did not, and chose himself to not do that.
Because of lack of money.
Okay, I've let you talk for whatever. It is my time. Am I clear on that? And all of that having been said, while this is unorthodox, this court does believe that it preserves the protections that the 56-day rule, the 2 56-day rules actually, have in place, in the intent of those rules, so that stale orders and other things don't happen. The defendant has had an opportunity, certainly, to be heard before this court on the first occasion back on September 3rd. The court heard the initial part of this, gave the defendant additional time, which he did not use to provide anything in writing or otherwise to the court regarding this particular proceeding. And it seems that his major beef has to do with the actions of the personal representative, counsel, the court, and everything else. And I guess prior to my going off of the bench, he, quite frankly, had not, as of yet, taken a shot at me, and was about to. And so I certainly needed to remove myself before I responded back, and may have responded back in an inappropriate fashion. But you can take whatever shots you want at me. I'm sure in whatever other hearings, my name will come up as somebody who has done something wrong to you. I don't think that I have. So, having said all of that, it is the order of this court that the order of eviction will stand, and that the execution of the order of eviction signed by this court may continue. The defendant may seek a stay if he wishes. This order to give the defendant an opportunity to seek a stay before the Oakland County Probate Court, this order will take effect for the continuation of it 7 days after the signing of my order. Thank you.
Should I submit the proposed order?
I really like having you guys here, but I'm going to do an order. All right. So if you want to wait, she's beginning that and should have it for my signature shortly. Thank you. Court recalls the case of New Parker Apartments versus Tubbs.
Same for the planning, Your Honor, our decision to wait for Ms. Tubbs paid off. She's here.
State your name.
Sherry Tubbs.
Okay. Where are we on this case? And then I have a question.
There.
Goodness. I usually don't bring my
That's what
phone.
we're seeing at us today.
I know, I never do that. I'm sorry. I never have my phone.
The sex offender registry still shows Mr. Gardner is living there. There's I found in there somewhere where it looks like there was some check made on 8/27 of 25, so August of this year. I don't know what it means. I'm not saying that means they confirmed it, but there's a date in August of 25 in the sex offender registry records. And I did a Lexus person search, and apparently his driver's license is at her address still. She acknowledges that it has not been changed. I given Officer Allen the default judgment. I think it could now be after hearing, and she's says she wants to try to get this done, and so if the court gives her more than the 10 days.
Yes, because we have went to the post office and changed all this mail, which last time I was here, I didn't know.
Ms. Tubbs, before you go on, have you been drinking?
Yes, I have a couple of beers, yes.
How much did you have?
I drank beer.
Okay, so how many beers did you have?
18 ounce or 24 ounce, yes.
Yeah, that's the nice thing about the 24 ounce. You can say I only had 2 or 3 beers.
So you, this morning? Can you get Teresa down here with the PBT, please?
I will say like 2 or 3 or 4 o'clock in the morning. Because that's what
2 or 3 o'clock in the morning, you started drinking?
That's what time I usually get up and drink beer.
Okay, so how many did you have this morning?
A beer.
Just one? One, what, 24 ounce?
24. Well, that's how it trade, yes.
So that's like 2, but what kind, what?
I don't know how much coming to 24 ounce.
24 ounces. So, what kind?
But Light.
Oh, of course. Bud Light. Why did I
Yeah,
ask?
I drink Bud Light. I used to drink Miller High Life, but I drink Bud Light. I used to drink a lot of liquor, but Bud Light. Why would you ask me?
Because I've got to determine whether or not you can adequately do this hearing. Mr. Allen, Mr. Allen, I'm going to give you a PBT.
What is that?
Okay, that's a preliminary breath test.
Oh, okay.
Okay?
Okay.
So here's what's going to happen. You're going to go back with Mr. Allen, and there's going to be a PBT. You just need to blow into the machine, and then we're going to see. Okay? Thank you, Ms. Tubbs. Watch your step. Okay, bye-bye. I know. Glad that's what came out of her mouth. All right. You know, there are times in life where I'm just afraid to call another case. Just kind of take a pause and you just hope.
Hey.
Are they?
They're doing what they do.
Okay.
Some people wake up in a number that would send other people to bed.
I know. You know, I was just going to ask for breakfast, really? I don't think. Off the record? No, I'm gonna say what I gotta say. Because
Okay. Right. Whoa, whoa, whoa. Whoa, 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 whoa.
Who's getting that turkey?
I'm not really sure, but I'm afraid to go back and look. Mr. Lloyd, is yours simple? Where's Lacy go?
Very fast.
That's what Magnus said. And then no. No, I'm kidding. Corey, go.
We heard you.
Oh, holy. Okay. Hold on a second. Miss. Okay, Miss Tubbs? Okay.
Yeah, I already know. I was drinking last night too.
Yeah.
And it is. I already know what it was gonna be, Miss Simpson.
Uh-huh. Okay, so let me first ask you this, and then I'll try to see what we're gonna do with your case. How'd you get here?
I got dropped off by my sister.
You didn't drive?
No, I don't drive.
That's probably a good
I don't
thing.
have a license, so I don't drive. I know how to.
That doesn't stop everybody,
And I'm
but
getting on the bus.
okay, so Mr. Pink, I don't know that I could say I'm gonna do this after a hearing because she is highly inebriated. She's a 0.224.
What does that mean?
It means you are seriously.
That's probably about 3 sheets to the wind. Never mind. You don't know what, off of one beer? No, you had more than one.
Okay, I play the drinking game too, so that's probably it. Oh, man, did I say that? I'm sorry. I don't play the drinking game.
But that wasn't beer, right?
That was.
You were just talking about beer before.
Yeah,
You were lying.
a beer at 3 o'clock or something in the morning, but I did play the drinking games the night before.
So.
You told the truth. And nothing but the truth, but not
I didn't tell the truth, whole truth. Judge Simpson, I didn't tell the whole truth, because I played the drinking game of life. I played the drink game.
Your Honor, the efficient thing to do would be to come back on Friday with a regular landlord tenant docket.
Yes, it would.
The kind thing to do would be to maybe come back the next Friday so she can have one more shot at trying to get him to the state police and get his ass.
No, but the state police is way out in, right now, I have transportation.
You don't have to go there. Willie Gardner's got to take care of this, or you're going to get put out.
Oh, he has.
Everybody's trying to leave it. Tennessee, we want to get on the team with us.
Oh.
So how about
Come on, Mr. Simpson.
26, Your Honor?
Come on, what?
Judge Simpson, I do not need to be kidding. I ain't had a permit in 15 years, and I finally got my own permit. I didn't know he was a sex offender or none of that stuff.
Okay, so.
But when I come back, I'm gonna be here.
On the regular docket on the 26th.
On the 26th? Okay, so here's what I'm gonna do. All right, I'm going to adjourn this, and it's gonna go back to basically a pretrial for September 26th, 2025 at 3 p.m. That's in the afternoon.
Oh, yeah.
Okay,
Because
so.
I'm gonna drink at 3 a.m. I'm just playing. I'm just playing.
Okay, I just. Ms. Tubbs,
I appreciate you, Judge. I really do.
Ms. Tubbs.
Just not after you get up off first.
I know, but Ms. Tubbs, here's, okay, I'm giving you basically 10 days to sober up. And get that.
I'm today. I'm not drinking no more today. I promise. I ain't gonna drink no more till the 22nd. I'm just saying. I just try to keep my apartment.
I know. So I'm not.
Two grandkids. And
Okay.
then that comes to my apartment.
Okay, I'm not gonna get into that. All I need.
31 grandkids, 10 kids, 31 grandkids.
31?
31 grandkids, 10 kids, 5 boys, 5 girls. And they love coming to my apartment. Just they don't live with me, but they just like to come and play.
Okay, so here's the deal. I'm gonna adjourn it out to the 26th at 3. Next time you walk into my courtroom, you need to be sober.
Promise. I got a Bible in my purse.
No, let's not do that. All right.
Bible in my purse. Look him up. Thank you, Judge.
Yep, you take care.
I am.
Okay,
Thank you so much.
go ahead and you just be safe out there, okay?
I'm gonna get on the bus. I didn't ride. Thank you.
You're welcome. No, we're not. No, we're not laughing at you.
Thank you.
Yes. How much you want to bet it's the wrong bus?
Any excuse?
Yes. Thank you, Mr. Finn. No, I'm gonna keep calling cases because it can't get any worse. Real Properties versus Jason Mitchell.
Your Honor, on behalf of Lacey, on behalf of the properties.
Isn't this great thing about our profession? You just can't make it up. Okay, where are you folks?
Almost out there. They tried for last Friday, was I think the deadline, but they had trouble with the auction debt. They need a little more time. There's going to be an order that if it wasn't effective till Friday, then they can get the last of it stuff out. So that's.
Yeah, so, I'm sure the court knows that there was an escrow order and there's been no escrow paid.
Correct.
Furthermore, they were supposed to be out last Friday. To my clients, not only are they not out, but there is another squatter living in this very unsafe building. So it is very important to my client that we regain possession just for the safety of the community and to begin working on the building regarding that. And so we've given them a lot of time. We do need the court to give us something where we can enforce our right to possession. I understand that we're going to work out the numbers after we're able to walk through the building and see what's there. But at this point, what's important is.
How long is it gonna take him to get the rest of the stuff out?
We should be out in a few days. We're picking up stuff. We got another truck this afternoon coming in. We're hoping by the end of the week.
By Friday. So I guess I'm trying to figure out, if I granted the judgment for possession today, right? He'd have 10 days, right?
Yes.
So there doesn't seem to me, after hearing, to be any tribal issue regarding the issue of possession. So a notifiable issue of granted judgment for possession. I'm not going to, although this is a non-payment of rent case, because of the defendant's indication that he was going to vacate, I'm not going to give redemption. There will be no redemption. And so a writ would issue, what's the day?
Today's the 16th.
Would issue the 26th.
Thank you.
I almost want to make you come back on the 26th to get your writ so that you can see Miss Tubbs, but I'm not going to do it. All right.
I'm making sure you wait, but, I'll have to.
All right.
Yeah.
Thank you.
Thank you.
Well, and I've got to give you a new date for the money claims, correct? Well, we actually had the trial date today, so I'll adjourn that. If, let's say they move it at the latest point, I don't think it's going to take them that 26. What's my October date?
Your first October date is the 14th.
14th. October 14th.
What day is it?
That's a Tuesday
9 a.m.
at 9 a.m. Yep.
Thank you.
All righty. Thank you, folks.
Before you call the next one, will you look at
Well,
your
look at
order?
order.
Yeah. Thank you.
In the court finding, the defendant does not physically reside in the office. This one. In the court after hearing finding and then list these out. One, that the defendant does not physically reside at the only property removed. In other words, see this order. Got it.
Mm-hmm.
Okay, just put a 1 and a 2 there. Court does call the case of Town Center Place versus Singrid Melvin. Pardon?
You might have to be loud. Sorry.
Oh, Miss Melvin? Come on. She's gonna need equipment. Okay, can you hear me, Miss Melvin?
Yes.
Okay, so state your name.
Cedric Melvin.
Okay, so a couple of things before we can begin.
Yeah.
You brought some things with you today.
Yes.
Okay. I was informed that you brought some things and I just need you to confirm. Did you bring like 2 dead mice?
Yes. And 2 pounds of dead poop. And
2 pounds?
And 2 filters from the heating unit that the management team doesn't replace. I have to do it myself.
Okay, so let me ask you this, because my understanding is that those items are still in our building.
Yeah.
it's called a proffer, but can you tell me why you brought them?
On the 27th of July, I was sitting having my morning coffee, and there was a little gray object in front of my apartment door. When I walked over closer, it was a mouse, a live mouse. So I used my metal garbage waste basket and covered it. I called the office twice, but nobody answered, so I had to go downstairs, and the maintenance man came up and took the mouse out. Well,
Go ahead.
yeah, I talked to the neighbors and they said, no, you have mice in your apartment. Well, I didn't know I had mice in my apartment. So let's start looking.
Okay.
I,
Okay, hold on 1 second.
yeah.
So you would be able to tell me all of that. Is there a reason why you brought these deceased mice
Well,
here?
so you would believe me, you know.
Okay, but my staff went out and said that you could take a picture, but you said for some reason that the picture wouldn't do?
Well, I got 3 cameras. And different times,
You have what?
I got 3 cameras. And at different times, they are being disconnected from the office. But they could all connect into the intercom system.
The internet?
Intercom system, when you get into the lobby, you press 314 to get into me to open the door so you can come in.
Okay.
Well, my system hasn't been working for years, courtesy of the office, and so I bought those today. I had to.
But okay.
Yeah, I know.
But I'm on the mice.
Okay.
What? You brought them so that I would believe you.
Yeah.
Okay.
Because I didn't know, you needed the evidence or just.
Right, but then my staff said, well, why don't you take pictures? And you said you can't, so is it that you can't take a picture?
No, the fact that they're not connected. Right now, I had to go out and buy a new phone so I could call for a cab so I could come here today. Because the office disconnects everything.
Okay, so ma'am, you. So you could take a picture of these mice and the poop.
Well,
I guess it's probably a better word, but.
I'm still kind of shocked that I have mice in my apartment. And I'm still.
Okay.
The pest control comes, but they don't remove the mice. So I would have to pick them out.
Okay, so let me ask you this. Besides the mice and you said 2 pounds of,
Yeah,
okay, besides that, what else is in the bag?
just the dirty filters from the air conditioning unit, because they don't come and replace them. So I have to go out and buy my own and do it my own. And I've been doing that for over 10 years.
Okay. So. And that's the reason that you brought it all, so that you would tell me that and then I'd believe you.
Yeah.
Okay, so here's what I need you to do. I have to get those things out of this building. Those have to get out of this building.
I take my right and put them in the garage.
Okay, so.
You want me to do it?
Oh, I'm not doing it. So you're gonna.
Just tell me where the trash man is and I take it over there.
Okay, but hold on a second. I take it, Counselor, you've not seen the mice.
Oh, I've seen pictures of the dead mice that she's left in the mailbox for my client, but yeah, I've definitely.
Wow.
Yeah,
Well,
so I know.
You know, no, but the
But I didn't see them as.
you know, you watch my day, really? So,
I can't,
these particular mice,
I don't need to see them, Your Honor. No, no, thank you.
all right, and just
You make.
as well as their, and I'm presuming they're friends, because that's a lot. The droppings you don't need to see.
I'm sure I know.
Okay.
Yeah, we're good.
What about the filters?
What would
I need?
The filters.
Oh, that's okay, so.
What's okay?
But Your Honor, the filters aren't an issue, so I don't really.
Right.
Okay.
But if she raises something about the filters, which I'm not clear what that is.
Right.
Do you see a need why I would need to see the filters? No?
Do you?
I have no clue today.
Same.
Okay, so.
Your Honor, in regards to the filters?
Yeah, so I think they're all together in one bag.
Yeah.
So, yeah, but so what I'm going to tell you to do is you're going to have to get that bag out of this building.
Okay.
Okay, so I'm going to give you a chance to do that. I'm going to let you take the mice, their droppings, and also the filters. If for whatever reason they come up, I'll figure it out.
Okay, which way to the trash can?
I'm not going to debate their existence, Your Honor. I waive that.
Thank you. All right, that's really what I needed from you.
Yeah.
All right, so you go out. We'll have somebody show you where you should dispose of them, because I don't want you just to put them in a trash can in the building.
Well, they are in containers and are sealed, so, okay. Okay, which way?
What they're in I don't even want to know. Just, they'll show you where to go outside of the building. They'll show you where the dumpster is.
Okay.
Okay? So you go do that. We'll be here. When you come back, we'll.
Do it to walk while you wait.
Oh my God.
I know you heard me.
Court stands in recess. Take me off. Melvin. Determined, I need a pen. I walked off with it. Thank you. All right. Let me, before we start out the trial in this matter, what are the issues that are raised by the plaintiff regarding determined, I need a pen. I walked off with it. No, by the plaintiff that are the basis for the termination. Thank you.
Issues that are raised, Your Honor, are that she has repeat lease violations that include keeping a balcony that is not fit with the house rules policy. That policy is put in effect to prevent rodent infestation, to prevent excessive clutter and debris, and
These are the pots on the balcony.
These are pots on the balcony, yes.
Okay.
There's also currently before this court that has just been submitted a health hazard situation in which she failed a health inspection, where the inspector found there was excessive clutter in her unit itself. And was filed before the court this week.
So that's another case.
That is another case, Your Honor, but it is before this court. Not today, but
Okay. Miss Melvin?
Yeah.
We went through this the last time, and I guess the issue of the pots on the balcony, you gave your reasons, but the rules are rather clear regarding the number of pots you can have on the balcony.
It doesn't say that, so.
It's-
That I hear from 2022. It says the balcony is mine to use as I want. There's no limit on pot. That's the rule the lawyer is trying to use to get me to move out. And I've been doing that since May 2022.
So we're not even in agreement that the rules say that, right? You don't agree that the rules, because what I read the last time, as I'm recalling, I did not keep a copy, was that there were 5 potted plants permitted. Specifically, also, there were no hanging plants allowed.
One of my neighbors, he passed away. He was in charge of the gardens. And he had 20 planters on his balcony.
Okay, when was that?
It was the first of the month, August, because he passed away in August.
Of this year?
Yeah. And his name is Phil Pope.
Do you know anything about that balcony?
relevancy, Your Honor.
Well,
Pertains to this case.
He died.
I get it, but do you know anything about that?
I don't, Your Honor.
No, I'm asking because sometimes, and I'll just say it this way, sometimes rules are enforced once they become a problem. You know what I mean? So like she could have 10 pots on her balcony, but maybe, and this is just hypothetical, if everybody else is not copying it, they kind of just let that ride if it's not really a problem. What I saw from the photographs of your balcony the last time, Miss Melvin, is there are a lot of pots out there. And there was a hanging flower basket that was, I think, on the curl of a railing coming down from the unit above.
Yeah.
Okay. Would you agree that you can't have the hanging baskets?
Well, yes and no, because I've been there since I moved in 2006.
Not those baskets.
No, well, they die and I get new ones come spring. And like some of my house plants are on the balcony too. So if I remove them, that means 5 plants less because they're going to be.
Right, but at some point, okay, I get it. But so if I take what you're saying, that you're allowed to use the balcony,
Yeah.
that balcony that the hanging pot is coming off of, that's not your balcony.
It's part of my apartment. I open the patio door, that is my balcony, and it goes from there.
No, right, but above you is the other is the next floor.
Yeah, there's 170 balconies, the whole house.
Right, but what I'm saying is, when you hang something from the one above you, that's the other person's balcony that you're using.
Oh, I don't know, because it's in the metal sticks and it has a.
Yes, I know. I saw it, but it's hanging from their balcony. So if you're saying you get to use your balcony, because that's what the rules say, the problem with the hanging plants is that you're using somebody else's balcony.
Well, I guess it can fit into it that way. But it's September now, so they're gonna be gone till next May, you know.
Okay, and so they have not died as of yet. The potted plants, I don't have hanging.
One died, so they've got 2 more to go, so.
I only saw one. There were 3 out there?
Yes, there's three. I have a current or an updated picture. You don't hold it to see it.
Okay, does it show that one of them is dying?
No.
Okay, all right, of course not, right?
Yes. Yeah, that copy is for you.
Yeah, but you can see.
Hold on, I don't have it in front of me yet.
Okay.
These were taken on 8/15 by Mr. Napier.
So August 15th?
Yes, Your Honor.
By end of this month, it'll probably be gone, because, you know, it's getting cold outside, 45 degrees at night, and the plants are dying. So that probably eliminated.
Okay, let me ask you this. Of the potted plants that you have out there, are all of them living right now?
Always have been what?
Pardon?
No, I didn't.
Oh, are they all living right now? The plants that are in your pots out there, are they living?
The carrots didn't come up.
Pardon?
The carrots didn't come up.
Oh, the carrots, okay.
Didn't come up. For some reason, Mother Nature is not growing like it used to. So the other.
Climate change.
And, one more pot, except I haven't been strong enough to move them downstairs.
Okay,
So, and this one here in the corner, that's my TV antenna.
Oh, but you, yeah, I know. So, but you have your TV antenna in a pot of dirt.
Yeah. So that, you know, it stabilizes it.
No, I get why you might do that.
I can't get cement or somebody, you know, carry it, so I have to do things myself. Nobody comes to help me.
Okay.
Now, let's see, well, the sunflowers are gone, they already died this week, so that's all eliminated.
Okay, let me ask it another way. Are there more than 5 pots right now that have like living plants in them?
Yes. Tomatoes, okra.
Okra?
And my spices, parsley and basil and things like that. So when I cook, I just have to get my fresh spices out of the balcony and into the kitchen. Because I believe in more natural products.
Okay, so Ms. Melvin, if I tell you that, let's say, I'm not saying this is what I'm ordering yet, but let's say I say today, you have to get that down to 5 pots.
That will. Because the sunflowers are there. Now, the question is, I have the pots, they have dirt. So can I leave them when they don't have nothing?
No, because the problem is not entirely the plant. It's that you have the pots out there.
Okay, in that case, will they reimburse me for the cost of the plant?
I don't.
I'm on Social Security.
No, I know, but why? Okay, so here's what I'm trying to figure out. You can't have more than 5 pots out there. That's what I see, okay? But I realize that you've gone through the whole summer with what you have out there. Okay? That's why I was asking what's died off already. And then what do you still have?
I still have 3 rose bushes. Those were presents from my family and friends for Mother's Day, my birthday, and that. And usually when we had the different management team, I would take those rose bushes and put them into our front yard at the front of the building. So we have like 15 rose bushes from. But this type of management, I'm not touching any rose bush. I'm not putting anything in there.
So you used to take the rose bushes and plant them outside in the front?
Yeah.
Okay. So you got the 3 rose bushes, and then what else? And those are in separate pots?
Yeah.
Okay. And then what else do you have that's still?
Just tomatoes, okra, and just vegetables, spices.
Spices. And are your spices all in the same pot?
Yep.
Okay. So that's 3 more pots that you have up there that have something growing.
Yeah.
Okay. So
I'm gonna be good till next spring.
yeah. So but the rose bushes, so these are kind of different for me. Okay, because the rose bushes are perennial. So that's going to come back, right? In the spring.
I don't keep them on the balcony.
You bring those inside.
No, I'm gonna put them someplace in the, we have 40 garden beds, so I can maybe put it inside my box garden bed.
What box garden bed?
They have a courtyard, and that is the next picture that I showed
Yeah.
you. That has personal boxes for people to utilize in the building. She occupies, I believe, 3 of those, the ones that are pictured here, as well as the overage that has gone over against management's agreement. Those are her garden beds, but Your Honor, she's requested more, and all the other residents only have 1. So the fact that she has 3 is way over and above what the management has done for any other resident in the building.
Okay. And these, just so that I understand, each resident basically has 1, she has 3.
Yeah.
But irrespective of that, these are where the residents have the ability to garden and plant.
As they see fit in the courtyard where it's safe.
Got it.
Which roommates do not penetrate the building, so to speak.
Why are the rodents coming and eating plants?
Because that's what they do.
Well,
No, they're looking for, well, okay, certain types of rodents, but really? You okay?
yeah.
Okay, can you hear me, Miss Snow? Can you hear me?
Yeah.
Okay. So what you,
It's sitting on my necklace, that's why I said.
oh, okay, I got you. Okay, so you have, so what you were planning to do with the rose bushes is you were going to take them down and plant them.
No, not with this type of management. I'm not doing anything except for them. I'm going to either give them to somebody or put them in the garbage.
Okay, so the rose bushes aren't going to be there.
No.
Okay.
And they're blooming right now.
Right. So they're still blooming right now.
Yeah. But, another week or so be gone. So.
Right. Well, probably got longer than a week, but and then you have the 3 others, which are still
growing?
Well, the tomatoes,
Tomatoes,
the spices.
right, okay. So how are you going to, if I tell you that you have to get down to 5 or below, right? So you got what I count as 6 different ones that are going right now, right? If I told you you had to get that down to 5, right?
Yeah, no problem.
Okay, so how are you going to get those off of the balcony?
What I'm gonna do, I have to take the dirt out of the bigger ones, and then put the small ones in the bigger ones. So you're still gonna have, 5 fans.
Okay,
The way that things going this year,
so you're going to take the dirt out of the smaller ones, put it into the bigger ones?
well, I was gonna put the whole pot into the bigger ones and take the dirt out of the bigger ones.
Okay. So if I told you that you had to get down to 5,
Okay,
how long will that take you to do?
a week.
You think you can do it in a week?
I've been doing everything else by myself in a week.
Okay, okay.
You should have seen me chase the mice for 4 weeks before the exterminator came and put mouse traps.
Okay, we may get to that, maybe not today, but at some point. So now,
And I bring up a different subject.
hang on. Whoa, no, not yet. Yeah, maybe not at all, but hold on. Hold on. Is there a rule or regulation regarding antennas? Because I'm not,
Do you want to see the regulation?
yes, I'm just wondering if you know of one.
Slide my hand him. You want the highlighted version or non-highlighted?
This is fine.
Okay. Your Honor, the other issue is that tomatoes, carrots, spices, and okra are not permitted to be on the patio as well. It specifically says no bird feeders or food or condition that would attract birds, bees, insects, animals of any kind are permitted. As she's testified, there have been mice present in her unit.
Yeah, but I don't know, who's gonna tell me those? Yeah, but I heard mice don't like okra. No, I'm kidding. I don't know. But
I don't know. I just know that the policy is in place to prevent rodents from infiltrating the unit. And we have a unit here with this exact issue in which it was meant to prevent.
yeah, but I guess what
It's my own.
I hear you. I guess what I'm trying to figure out though is, are the plants that she has, who's gonna be able to tell me those attract rodents? I mean, because I don't know that myself. As opposed to any other type of plant. I mean, hold on, man, just a second.
You want me to?
I mean, who's gonna, would there, I realize we're just here and there aren't necessarily like expert witnesses or anything because, yeah, but I don't know of my own knowledge that what she currently has attract rodents. Now, granted, some of these,
Pardon?
Tomatoes, carrots, spices, no. Although the carrots didn't grow supposedly.
I mean, when I had a garden outside, but these mice were gonna be wherever anyway. I just don't know that, what floor do you live on?
According to
Third
Google
floor.
AI,
Third floor?
Yeah.
according to Google AI, Michigan mice are attracted to vegetables, both gardens and harvested.
So how do I know I have Michigan mice and these weren't from Alabama?
Potatoes, staple foods. Fruits.
The mice came to my house the 26th of July.
They came to your house?
And when did the tomatoes, spices, and okra start growing?
I'm gonna be a bit hard pressed to enforce the rule in a fashion where somebody can't grow tomatoes.
I understand that.
Yeah, I mean, I think
And I'm
that,
trying to split hairs. In this picture, there's 18 pots that I count, including the hanging pots.
know.
And, there's a way in which you can keep tomatoes from attracting mice, and like by putting fencing around it, etc. What?
why do you want to go there?
I don't really want to go there, but I am saying,
Yeah.
but I'm saying you can look at the other two balconies that are in this picture that have like plants on them. There's one up at the top of the corner and one right there. And there's a huge difference between their plants and her
But see, I agree with you on that, but I would suspect
She's also on the third.
that more than the type of plant itself that might attract mice, to the extent that's what's happening, it's probably just hang on a second, I'll get to you. It's probably the number and the
value.
Yeah,
I think that's more my argument so far, than vegetables. It's just that, she's on the third floor here, Your Honor, they can climb. I mean, this is directly under.
I know mice can climb, but I think those are flying mice. I think they came from the 10th floor.
I think they can fly.
Yeah, I've seen flying mice. They're called bats.
And Your Honor, this picture was taken directly under her unit, so you can kind of see the building reaches here.
Right. No, I'm familiar actually with the building itself. I just, okay, what do you want to tell me?
I've been there since 2006. I started the gardens together with Going Home, and we paid for the land and for the garden, all that. And the mice were in 2006 not there. The mice eat cardboard. Because I haven't figured, they eat cheese. No, I got cardboard that should have bought. You could see where the mice eat.
Okay.
So they didn't eat my plants.
Okay, I don't know if they have or have not.
No.
Okay, I think we might have to have the mice as witnesses. But I'm.
We just threw them out.
Wow.
Hey,
really?
Hey,
Wow. 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 That was way too quick that you said that. All right.
Okay.
With how your day's going, come on.
Yeah, I know. That was pretty good. All right.
On the other hand, we
Uh-huh.
have 170 balconies. How come I'm the only one that get persecuted?
Okay, but look, just if you look at the picture,
Yeah.
look at how the other balconies are.
Because they have a social security check that doesn't pay enough to get flowers or anything.
Well, I don't know.
We're dealing with Section 8 section people.
Okay, but I don't know that that's the case with all these people.
Well,
I would just say
some people don't like that.
that's true. So, but what we've got to do.
Some people put their bicycles on the balcony and they have strollers but boxes on it. The lady has to go stuff at the flea market. She got plastic bags on her balcony.
Okay, but here's the problem. there may be other balconies with issues.
Yeah.
Okay, but that doesn't mean because they have issues, you don't. So here's what's gonna have to happen with the balcony. The hanging pots have to be removed. Right, so what I'm gonna permit is that the hanging pots, we're gonna probably have to do this in the form of some type of order. But the hanging pots, once the plants have died, the flowers have died, and or December 15th, whichever comes first, those have to be removed and you can no longer have any hanging plants.
No problem.
Okay,
You're stretching it all the way to December 15th, Your Honor?
I'm just thinking of when our winter comes.
I don't know.
Because I don't, yes, I'm going to the 15th with them.
Last year it was like 70 degrees on December 15th.
Yeah, but December 15th, you'd have to get rid of them anyway. Yes, I'm going to December 15th on those.
That was my question, Your Honor.
That's it. So you knew the answer before you asked. All right, so with the, have your rose bushes stopped blooming yet?
No, there's still got one died and there's two more blooming. Matter of fact, it's kind of late. It started about 2 weeks ago.
Yeah,
It was like, what's going on with me?
mine did too,
No.
and something has to do with the heat,
Yeah.
but so, and the type of rose that you might have. But you said one of them's dead?
Yeah.
Okay. So the one rose bush certainly has to go.
Yeah.
Okay. So you said you had spices?
Yeah, parsley and basil,
Okay.
okra,
You had your tomatoes?
yeah. They're still green, but.
Right. And you had your okra?
Yeah.
Okay.
And the two parts where they call the sunflowers are in, they are empty, because the sunflowers are gone.
They're probably dead. Okay, so. Here's what I'm gonna allow to have happen right now. The two living rose bushes you can keep on the balcony. Okay, because they're in separate pots, right? And then your three that you have, which have the tomato, okra, and your spices can stay. Okay? And then all of the other pots have to go. Okay? Now I'm letting you keep the hanging baskets. I get them. I get the concept. I'm going to let you keep those until they stop flowering, and then they've got to go. And they don't get to come back.
No,
Okay? So so you understand, if you get rid of or do something else with the rose bushes, next spring you can plant something else, but you can't have more than those 5 pots. Okay?
Yep.
So you say you can get all of those pots off in a week?
I gotta get a shopping cart or a trash barrel to put them in so I can wheel them outside the building. We used to have shopping carts, which made it easier, but now we're kind of playing games. So I have to figure a way
How to get, okay.
I can't carry it by myself, so I have to put them in a shopping cart or a trash can. Otherwise, it's October 14th.
Okay. If counsel, outside of what may be your objection to the hanging baskets, but I think I'm going to remain firm on that for the moment. That basically addresses what plaintiff's issues are. right? With the potted plants? No?
No.
Why?
All this vegetation behind her boxes is causing damage to the building.
Where is it that she's got to take care of that vegetation?
She planted that all.
The vegetation?
All this, yeah, all this stuff.
Except for this bush, right?
What damage is it causing to the building?
Good. Yeah, I.
Don't you do that, ma'am. Do not wave your head like that. That is a legitimate question on my part. You can't come in here just accusing her of things, telling me she's doing something to cause damage to the buildings and not be able to back it up. Am I understood? Am I understood? Counsel, you better check your client. I'll be back. Courtroom stand in recess.
Oh.
Taking a break.
Stephen James Bowen, 25I-718-730. Where is Mr. Carmen?
Morning.
I need your lawyer.
Is Tony there? Oh.
Go ahead. Why don't you have a seat, sir? Okay, so the Ross Young family, I don't know what to tell you. I got all these names and people on here that I think I've already called their case. And who else? Samsung S9, was that Mr. Castro, I believe? I think.
You may be seated.
Thank you. Okay.
Where we were at the last point was the vegetation against the building, which I. Go ahead.
After meeting with my client and conferring, we just like to make it known that as is our obligation, we are going to maintain that area, remove everything that has been planted and overplanted. And as is their property and not hers, we're not going to allow her to plant anything else there.
Well, my question is this.
Yes.
The stuff that's I'm looking at this picture. Are you talking about the stuff that's behind the boxes, or do those boxes go all the way back to the wall?
They do not go all the way back to the wall. There is like a good maybe 1 or 2 inches of space in between the wall and the box. So it's like a 4x4 box or so. I don't exactly know how to explain it, but.
Well, it looks like it's about 2 in the front. But is it like it's like a rectangle?
It's like a square.
But the 2x2 square, what I can't get is the depth of the boxes going back.
Right, because of all the vegetation there. And so.
Well, not entirely because of the vegetation. It's because if you're telling me that they're square, then I could, just by looking, say at that first box on the right, I can estimate how far back that goes. But what I don't know is how close is that to the wall? And it's really the angle of the photo.
Yes, Your Honor.
That I can't.
Let's see if the other photo that I have shows it better. Yeah. May I?
Yeah.
I have an older photo, Your Honor.
Okay. That may help me.
Yeah.
Because the other, I'm looking at the tall plant in the back. Okay, gotcha.
So
okay.
Our only statement, I guess, would be, and my client is deeply sorry for her attitude towards the court. However, this has been an ongoing problem and she kind of let her emotions get the best of her. But there's like this little fencing that she put up, and the planting is, she kind of continues to do it. So they're gonna.
The little fencing.
The first picture, it's kind of white. It's like down here. You see it?
Oh, I did. Okay.
They're gonna have to remove that.
Like the stake fence.
Yes.
In the.
They're gonna have to remove that. And as it's her property, it's just. She's just.
So the idea behind these is that whatever's planted should be in the box.
Yes, absolutely.
Got it.
So I think all my client is just trying to convey is that they are going to have to rip out and maintain the rest of that from incidences and occurrences they've had with Miss Melvin in the past. Those have not been pleasant. And so.
Got it. So I get the white fencing. I get that.
Okay.
My question though is, when I look at these two photos,
yes.
Thank you for the older one.
Yes.
The tall item going up the back, if I'm recognizing the leaves on it.
Yes.
Doesn't look like. Really? I don't feel safe in it. What is that? That almost looks like a sumac. Which, yeah, coming up the back.
Could be, Your Honor.
And the only reason I mentioned that is because that's not something that she would have planted. What I don't know is if she does nothing behind there, but something naturally comes up. What happens then?
Right. So all the other boxes they typically maintain because she's had the property. They're during these proceedings, had left it alone because she put the little fence up there and she continues to plant things because they wanted to avoid a situation in which they were ripping out her property. And since plants are considered a person's property, they wanted to make sure the court was aware that as that is not permitted for her to plant on the private property of my clients, they are going to have to go through and rip that stuff out, even though she has claimed it with that small fence. That's all the point that I was trying to make, Your Honor.
Okay, so what I,
Do you follow me? Does that make sense to you?
yeah, it does, and I just. So, well, I just want to check something. Ms. Melvin,
Yes,
you didn't, the boxes that are down on the,
yeah, I had growing home put them in.
Pardon?
At growing home put them in, and I got the permission from Ed Tucker. He was our residence principal, president when I moved in. So this box has been there at least nicely since.
no, I'm not having a problem with the box.
Neither are we here.
What I, behind them, so there's stuff to the side of the box. You didn't plan anything. Did
No,
you?
because elderberry bush grows up, morning glory grow up.
Right, but so.
That was that before I moved, and before, they cut all the bushes and flowers around the whole building and replaced it with mulch.
Got it.
Which brings the rats in.
Right, but here's what I'm gonna ask you.
Okay.
Behind did you plant anything behind the box?
No.
And I'll be honest with you, counsel, that, I mean, I may be wrong, but as I'm looking at
Oh.
the leaves of what I can see.
Your Honor, I'm not going to debate that. I'm only saying that there's the little
Clean, I think that's a part that the landlord.
is definitely going to take care of. I'm only
Yeah.
saying the part in which there's that little fence there makes it appear like she's trying to continue planting. That was not put there by nature. That was put there by a person.
Right, but did she plant anything behind there? You see,
No, behind
you see the little white fence, Miss Melvin?
It's
white.
I'll point it out.
Yeah, because you may not pick it up.
It's this right here.
Oh, that protects the plants on the Michigan cactus growing.
Oh.
And that's why that little white fence is there, so when they come and cut the grass, they don't cut the flowers right there.
We have to remove that.
Okay, so whose Michigan cactuses?
Yes, Michigan cactus,
Right, I know, but whose is it?
it's mine.
Okay, did you put it there to?
Yes, I put.
Okay, so Ms. Melvin, so here's the deal. I understand what you were doing with the cactus. The cactus has to go in the box,
Okay,
okay?
yeah,
All right, it can't be out to the side. So that area that you put the fence up to protect, they're gonna have to clean that out,
all right, no problem.
okay? They're also gonna go behind those boxes. You see what's kind of growing up there in the back?
Elderberry bush. I cut it
Pardon?
this week. I cut it this week because I harvested the elderberries.
Is that your elderberry?
Yeah.
Well, that's not yours, is it?
No, I didn't. plant
It was just, it came
It came out
naturally.
there like the morning glory comes out and the fennel comes out.
Yeah, I may have that wrong, but that certainly looks like a native plant to me.
And we're not,
Behind it.
yeah, we're not debating that at all. We're just stating that we have to remove all of that. And that was the issue in which my client was trying to present, that those plants need to be removed as they're posing a damage to the building. And we didn't want to stray.
Yeah, but that's not,
Okay, but Your Honor.
that's not her damage.
No.
If you don't take out those natural things growing next to building,
Absolutely. But what I.
so they can take them out.
When
It's
they
not
do
her.
it, they have to do the stuff that she planted as well, because that's not her property to plant on. And they didn't want to create,
What did she plant out there?
she just said she planted the cactus.
Right, and she also just said, I just told her she needed it moved.
Right.
So counsel, here's my problem
So I'm
with
not
this.
trying-
No, here's my problem. My problem is Miss Melvin is a very definite person. She has her beliefs and she has that, but she needs to be treated like a human being when asked to do something. And I just don't get that that's what's happening with her. Because I sit up here with this robe, but when I tell her everything that she wanted to have happen and everything that she was giving me her defense to, that this is what she needs to do, she's fine with that.
But you're not.
And I'll just say this also. What was very clear regarding the things behind there and what your client said was that she was doing things to cause damage to that building. She's not doing that.
And I spoke with my client and we talked about it, that they have the right to remove that.
I am not disputing that, counsel. I'm not disputing that. What I'm saying is, because that's behind there, she's not trying to cause any damage to the building. She didn't plant that there. It's a native plant that's coming up. I get why your client may not have wanted to go behind there with the case pending, but that's not her fault.
No.
I mean, it just.
Your Honor, we agree with that. It's not her fault. We did speak about that. And I do agree that any plant that is naturally occurring, they do have to maintain, and they do maintain the grounds. However, the little fence there, as well as the cactus in which she planted, gave them pause. All I was trying to do was put on the record that they do have to go in and clean that up to prevent any further damage.
Ms. Melvin, they're gonna move the fence.
Yeah,
You're gonna move the cactus.
I heard you. Right.
Right, I know you can.
I have one question. And about 2 years ago, one of the managers went crazy and remodeled my apartment and also attacked my garden. I had patio bricks between the boxes that would keep the sand from running down. I would like to have a reimbursement for those patio bricks because they've been doing stuff and.
I don't know what the patio bricks are.
I know they're 4x4s. You put them,
Well, I know, I know what a patio brick
Yeah,
is.
but they take stuff out, like remodel my whole apartment. Now, my bookcase is on that side, where all the electric outlets
All
are.
right.
And then the couch is in the middle. So when I have to plug something in, I gotta crawl over the couch. They ain't got no right to come into my apartment to move it.
Okay, but
Yeah.
Miss Melvin. Have a seat, Miss Melvin, have a seat. Okay.
And
You talked about two different things. Okay, and the patio, so here's how I understand. The patio blocks, if they're outside,
No, they removed them.
right, but if they were,
Yeah,
they could remove them.
yeah. Well, they shouldn't move them because when it rains, all the dirt falls down in front of the boxes. This will keep the dirt back.
That's what you're trying to do. Okay, gotcha. Okay.
Oh, one question. Which company started this lawsuit? Is it Rose Management? Is it Winfield or Town Center Place?
The plaintiff in this case is Town Center Place.
Town Center Place.
Yes.
So which company owns Town Center Place?
I don't know.
Yeah, see, that's it. Because if it's Town Center Place, these are the rules and my rights, not this, what is it? This house, these house rules. These house rules are not made by HUD, they're made just by Rose Management.
Okay.
So-
Ms. Melvin, I'll get back to that in just a second, okay? What were you gonna say, Counsel?
I was going to say, Your Honor, before commencing this lawsuit, I had a sit down with Ms. Melvin to discuss the plants on her porch. I had a sit down with her. She had counsel present. I did explain that she is welcome to keep 5 plants. We talked about the policy, why it was important for the policy, et cetera.
When did you talk to me?
We had that meeting back in May, Your Honor.
Okay.
We had that meeting?
Oh, it was in June. It was shortly before my birthday, Your Honor. It was back in June. Okay, and we had that meeting, we spoke with her, we sat down, we have sent several letters. And this entire time, we have kept an open communication with Ms. Melvin and attempted to talk with her in a respectful and.
Counsel, I am not saying that you did do that. I have some serious concerns about how these folks are being treated. I don't like it. And since you brought it up, I don't like it when at the last hearing, I have 2 town center cases.
Yeah.
And there are these 2 elderly women complaining about not having a television clicker.
Like I said, it's always.
Oh, okay, Miss Melvin, hold up. Miss Melvin, I got it. Okay, hold on. And then the basis for why that's occurring, I maybe can understand, but to hear them say things where just certain basic dignity. I mean, how would you like it to live someplace and the television, because of what's going on, because I'm not inventive enough to think of another solution, that whenever I leave it on Friday, whatever channel I put it on is what you guys have to watch the whole weekend until we get back on Monday? And I don't care about the justification, even if that's overnight. You know,
You're talking about.
I think that she doesn't fight back as to you because you are respectful. I think she fights back against management because as I watch those 2, and I don't want to call them elderly, but those mature women, just complaining about what's happening to them. And maybe some of it's legitimate, but it concerned me that they don't have a social work. They don't have. There's a problem here that this communication isn't happening in a respectful way to just explain to Ms. Melvin, you can't have these. And to kind of work with her. The whole conversation that I had today about what plant she had, this and that, I don't get it. And it's problematic, and quite frankly, I don't know that senior citizens should be treated that way. I get they're providing housing, I get all of that, but there's a whole lot that comes with that clientele, that population.
And I think that kind of comes to the placement and essentially where they're at and the services in which are honestly equipped to offer. They're not in assisted living, they're in independent apartments. And so
I know, counsel,
I know.
I get it. But what I'm saying is that population has certain needs. You can defend your client all you want, but I'm going to tell you what, God willing, when we all get there, if we get there, there's a certain dignity that people have to have and a certain dignity in how you treat people. And I haven't seen it.
Your Honor, respectfully, you probably have not seen it because the cases that come in front of you are the ones that need to come in front of you because you have to solve them.
Yeah.
But our building has hundreds of more units that do not come in front of you. Hundreds of people that have been there for a long
Counsel, you don't need to explain that to me,
Okay.
but if you're gonna try to lecture this court, you better stop and slow your roll.
My point was not to lecture the court. My point was just simply to show that Melvin has been given lots of respect, Your Honor, and this hearing and every other occurrence that I've had with her that I've heard from management.
May
as
I
well.
have the floor? Well, I had to replace four, well, there's another phone.
Okay, but Miss Malvin, hold on, that's not before me right now, okay? Now, Mr. Allen, you were holding up some rules you say apply? No, no, hold on. When you said that remember when you just asked me about it being town center or who was bringing you here? Right? And you were holding up something different.
This is a letter why I don't have a lawyer right now, because when they call my phones, nobody answers. I had to go out and buy another phone. Either my internet been disconnected and my desktop's disconnected and everything runs through the office because the office controls all these electronic things. So that's why here's a letter from legal services saying that they can't reach me by phone. My doctor can't reach me by phone. My kids can't call me. I had to
All right,
go get
okay,
another
but, well, hold on. You guys don't have anything to do with the phone, do you? Okay, I didn't think so. All right.
Because when you get into the lobby, you put in my apartment number and supposedly ring into my phone so I can press 6 and let the person in. But my phone doesn't. It's
So the intercom is hooked to some app.
No, it's that word.
The intercom is hooked to the telephone line in which any telephone line, whether it's a cell phone or a landline, can hit 6 and allow the person to come in. So it doesn't have to necessarily be a cell phone line, and that is.
So. You asked me this question, but why do you think they did something to your phone?
Pardon me?
Okay. Why do you think they did something to your phone?
Because I can't call out. I can't call for 911. So I had to go get another phone the Thursday so I can make sure the meeting is here and all that. They sent me a letter that the date was moved from the 16th of September to the 26th of
that was not
May. So I went down to the library and the librarian checked into the
Okay, but Ms. Malvin, Ms. Malvin.
16 is still the legit, but all that paperwork I got, I took it down to City Hall, to the City Council.
Okay, but listen, right now, right, you have a phone that works and you can, so that your lawyer, your doctor, everybody can get through to you. And you can still open the door with hitting the 6 if you had to, right?
But the new caption phone that they advertise on TV is hooked into the internet, but when they disconnect my internet, the phone doesn't work. So there's 4 phones actually that I have.
Okay, so who disconnected your internet? Who disconnected your internet?
I am.
You did?
Yeah, I got a desktop and I got an Apple, but it ain't working. And my phone's not working. That's why I had to go back, get a new one Thursday.
Do you guys supply internet? You do not? Okay, so.
I've been there since 2006.
No, I know, but Ms. Melvin, who pays for your internet? Who pays for your internet?
I do. I play Comcast.
Okay. Did Comcast come do something to your,
No, I went on the computer in the library, and the librarian helped me, and I stated my problem, and they didn't come back and they didn't answer me back.
okay, so here's what I think you need to do. Because the landlord doesn't supply your internet, you supply your own. So your issue may be with Comcast.
Yeah, well.
Okay, than that, but it's not something, what you're telling me is not something that I think they've done. It's gonna be a problem with your internet, okay?
One time they sent a young man over, and he sits in the doorway and said, oh, the modem works. Yeah, well, that was it. And here's like the letter says.
You feel the same way about Comcast that I feel about DTE.
But it's all the same thing. If I can get copies, I can get the phone. That
I know.
have an attorney
No,
to do.
I get it. I get it, but I can't do anything regarding them.
It's okay. I'll be someone.
Oh, what are you saying?
I'll be someone.
Okay, all right. Find somebody at Comcast and maybe they can help you, okay?
Well, this
All right.
is a Department of Civil Rights complaint. And Department of Housing Urban Development. It's not that I'm not doing anything, I just gotta get help, and nobody wants to help.
Okay, all right.
Pick on me.
So here's what we're gonna do, all right? You said you can have, okay. You need to get that Michigan cactus moved,
Yeah.
like as soon as possible. Get that into one of the boxes.
It's beautiful. It's one of my friends has them in a driveway.
Uh-huh.
First time he told me you're missing a cactus. I said, you don't have no cactus. Yeah, the beautiful yellow blossom on there.
We actually have two
Yeah,
kinds of
no
cacti
problem.
that are native to us, but that's being different. All right, so get that moved in to the box. They're going to come along and they're going, okay, so Ms. Melvin, I want you to understand.
They're cutting it off, you know.
Right, so, but they're gonna take that white fencing out, okay, they're gonna move that. Did you want it or you want them to just get rid of it?
Okay, now the other question.
No,
Oh,
the white fencing, do you want them to,
I take care of it.
you wanna take it out? Okay, then that needs to go right away so they can get behind those boxes and clean it out.
Well, there's a green fence in front of it, so, but I take care of it.
Okay, so let me do it this way.
Can't see the green fence on.
No, it's okay. So whatever fencing you or barrier you put down there, because of the mowing or whatever, that's gotta come out. Okay?
Yeah.
So that they can get behind there and then behind those boxes.
Your Honor, could
It's
you
an
give us,
elderberry bush that comes back every year.
Yeah, I know.
could you give us a date in which we can expect her to have that removed and us to be able to go?
What?
When can you get the cactus and the two fences out of the way?
I don't,
Okay, you gotta move the Michigan cactus into the box, right?
no problem.
And then there is the white fencing and you said there's some green barrier.
Oh, I'll take the white fence out.
Okay, so hold on. When are you gonna do that? How soon can you do that?
Probably this week.
Okay, why don't I do this? I want that, I want the Michigan cactus moved. And the fencing out by Monday.
I wanted,
The 22nd.
should be okay.
Today's Tuesday, so that gives you about a week to do.
As long as it don't rain and the floods will come, I will complete.
I think you can move fencing and the cactus in rain.
Well, they
Okay,
got stickers, and when they stick, it hurts.
you mean the cacti?
The cat.
Yeah, they got, okay. So I want that,
the fencing out, that's gotta be moved by Monday, okay? Now, the hanging plants we dealt with,
Yes,
everything's gotta be out
December 15th, you said.
December 15th.
Okay.
Now, house, you say you can get yourself down to, you can move out those other, well, the pots
Yeah.
off of the balcony.
Well, I'm not gonna move it off the balcony. I'm gonna put the smaller into the big one, then I'll.
And then move, okay, I got you. Whatever, they have to be off of the balcony. Yeah,
Pardon me?
they have to be off of the balcony,
What?
the pots.
All of them?
So you were gonna take, let me just see if I had this right, because I didn't think that this is what you were doing. You were gonna take the smaller pots,
Yeah, because.
put them inside the bigger pots,
Yeah,
and then call that one pot.
yeah. No, because the big part, there's nothing growing right now. The sunflowers are gone. So I'm gonna take the pot with the tomato and take the dirt out and put it there. So in the bigger pot. And the same thing with the other one. So I will do 3 pots.
Okay.
Is the landlord gonna come and pick up the mice?
Well, ma'am,
Well, I'm not happy getting into the apartment.
okay, hold on a second. Okay, so I guess I was under the assumption how are we defining small?
What's the question?
How are we defining small?
Your Honor, I think 5
Small. the
five
pots
visible
or-
pots. in
Hold
this
on.
case. I think 5 visible pots in this
Thank you.
case
That-
would be preferable. I don't think that we're gonna split hairs over small or large. I think
Okay.
just
Got it.
considering we have 18, if we really could just get it down to 5, we're not gonna split hairs over the enormity of one pot versus the other.
18, what do you see, 18?
Well, it's okay. It's okay. Here's Miss Melvin, here's what we gotta do.
Also.
We just have to get that to 5. Okay, now the one I haven't dealt with is,
The antenna.
Antenna.
So we're okay with the antenna itself being in a pot as long as it is secure. We just don't want like in the sand securing it. We don't really have a policy on antennas necessarily. She's only allowed to have one antenna. That's kind of what the policy says, and it has to be secure and safe.
so, okay, so then the question becomes, does that count as one of the, no, okay.
No, we're not gonna count that because that's an antenna, right? So like, if that's what's securing it, that's what's securing it. We're fine with that. But plants growing out of pots, let's keep it to 5. Let's not split hairs over big or small.
Okay,
We're trying to compromise.
okay, so here's what we've got. So that stuff has to be moved out, the cactus, we got that by
Well,
Monday.
I'm gonna not so much move out as reduce it. Let's put it that way.
Reduce what?
The pots. Let's put the.
Right, so how can you get all of that done by Monday?
By Sunday?
By Monday,
The 22nd.
the 22nd. Can we get everything done by the 22nd?
Well, between catching mice and vacuuming and all that, I guess I should be able to do that. I'm only 83 years old, so I have extra engineering.
Okay.
Yeah, very much protection from management. Hey, can she put back our water fountain, which is a Michigan state law? They took the water fountain out. Can we get our trash room back open so the trash can go in a room and doesn't stay in the hallway when the people, the wheelers and walkers can't park there. Wheelers and walk in the hallway, but she puts 3 garbage cans out there.
All right. So here's the thing, Ms. Miller.
Yeah, I know.
No, it's okay. I want these things dealt with. I need those pots reduced to 5,
Okay.
okay, on your balcony.
Okay.
Hanging plants can stay for right now, okay? And then I need you to move that fencing in the Michigan cactus.
Yeah.
And you're gonna do all of that by the 22nd, so that by Monday, huh?
We have a new court date.
I'm gonna give you another date to come back, because I want to make sure that's done.
Thank you, Your Honor.
Also, I want permission for her not to come into my apartment or send people in from my apartment and take pictures. It's a violation of Fourth and Fifth Amendment.
Okay, yeah, okay. So
okay, say
hold on a second. I'm assuming that some of that, whether it occurred or not, whatever is in regard to the other.
The health hazard, yes, absolutely, Your Honor.
Okay, then I'm not dealing with that right now.
Yes, sir.
Okay, so that's what I need to have happen by Monday.
Okay.
And then what's my next?
Your next date is September 12th.
Okay, and so then you're gonna be back on the 23rd to be able to tell me what's done. I realize you may not have cleaned it out by then, but as long as the stuff isn't there, then
The 23rd, we're coming.
the 23rd
At what time?
at 9. And hope it's not like today. Yes, ma'am.
Do you want me to take pictures of the balcony?
Yes, I'll need some follow your attorney's advice. I'm gonna need something to tell me what it looks like
To come back.
on the 23rd.
Yes, Your Honor. Okay.
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 And I'm assuming the plan is to deal with the health hazard as it comes up naturally in the course.
Yeah, do you don't have a date on that yet?
We submitted it, I think, on Monday.
On Monday?
Uh-huh.
Yeesh.
It could have been last Friday.
Case.
Let me look up it.
And then I can tell you what, if they processed it, if you submitted on Monday, let's say, I'll just make the assumption, if they processed it that same day,
yeah,
you're gonna probably see I don't think the 26th one.
Yes, it's not.
They haven't processed it yet, so you're probably looking at the first part of October. So
Should I have my internet?
the 10th, likely the 10th. I'm
We
sorry?
have nothing to do with the internet or phone connection.
What are you telling me, ma'am?
Well, I forgot the phone and they connected to the lobby. Nobody can call me and I have no service, so I have to.
Okay, but Ms. Melvin, I thought we dealt with this. Listen, you've got a new phone now, right?
Yeah.
And on that new phone, people can call you. People can call you now with the new phone that you have.
I have to give them the phone number first.
Okay.
But I'm not gonna give it to the office.
Okay, I'm not forcing you to give anybody your phone number. Listen, so that we can put this to bed, they don't have anything to do with your internet.
Oh, I hope they heard that.
So, yes, so you gotta call Comcast,
Okay.
okay?
Been going through this for a couple of years, you know.
Yep, so we'll see you on the 23rd, get all of those things done, and then we can kind of deal with this, all right?
Okay.
All right, thank you, folks.
Zoom?
Pardon?
Is that Zoom?
Is it Zoom? No, you need to come down.
No, I mean.
Is that what you're seeing up there?
Yeah.
That's Zoom.
Good, everybody in the neighborhood is watching it. Last time, when I walked in the building, they said, oh, I said, I'm like, huh, what do you mean? I didn't know, even when I walk around the streets and so, people say, oh, I see you on Zoom, thank you.
I get the same thing, Ms.
Even
Mel.
the downstairs department, they are so glad I am doing this.
Okay, All right, good job. All right, we'll see you. We'll
Yep,
see you.
we'll see.
Take care.
Thank you, Lawyer.
Court's in recess.
All right.
I guess
with a maximum indefinite of 16.5 years. Parties make a joint recommended sentence. The state would agree to count 2 and 3 merge for sentencing. The state would elect to proceed on count 3, kidnapping a felony 1. There's an agreement to a definite sentence of 8 years to a maximum indefinite sentence of 12 years. Mr. Brown would be required to register with the Violent Offender Database as a principal offender pursuant to Revised Code 2903.42. He has registration requirements as a violent offender, and there's mandatory post-release control, not less than 2 years, up to 5 years. Mr. Oswald, have I stated this correctly?
Yes, Your Honor.
Okay, Mr. Brown, do you have a good understanding of what you're doing, sir?
Yes.
Okay, I want to go over your constitutional rights. We then will go over this notice to enroll in a violent offender database, and we'll go over the Reagan-Tokes definite/indefinite sentencing, so you understand that fully, as far, and also post-release control. You have a right to have a trial in this matter. You're entitled to have a trial by a judge or jury of 12 people. If you have a jury trial, all 12 members of the jury would have to agree that you have been proven guilty beyond a reasonable doubt. Do you understand that, sir?
Yes.
I think we need to address whether the victims have any input on this.
Yes, Your Honor, we've been in consultation with the victim in regards to all the resolutions for all 4 of the defendants, including Mr. Brown's resolution, and she is in agreement with our resolution for the case today.
Okay, thank you. In addition to having a right to a trial, at trial, you have a right to confront every witness who testifies against you. Do you understand what that means?
Yes.
You have a right to have witnesses ordered to appear and testify at your request. Do you understand that right, sir?
Yes.
You have the right against self-incrimination. You do not have to prove anything. If you go to trial, the state has to prove the case against you beyond a reasonable doubt. You do not have to offer evidence, and you do not have to testify. If you choose not to testify, it will not be held against you, and I would in fact instruct the jury they could not discuss the fact you had not testified. They could not consider it or discuss it during deliberations. Do you understand that?
Yes.
This carries post-release control, which is supervision by the adult parole authority. It's mandatory, and they can supervise you for up to 5 years. They have to supervise you for at least 2 years after your release. If you violate the terms of post-release control, the adult parole authority can send you back to prison for 9 months per violation, up to 1/2 your stated sentence. Do you understand that?
Yes.
If you are convicted of a new felony during that period of supervision, the court that has the new felony case can revoke post-release control, impose whatever time remains on supervision. If you have less than a year remaining on supervision, they can add a year to the sentence. Do you understand, sir?
Yes.
The one thing that's a little unclear in the law right now, so I want to tell you to consider the worst case scenario, and that is what is the 1/2 of the stated sentence. Your stated sentence is a variable. It's 8 to 12 years. And wait a minute, 8 to 12 years. And I'll explain that. But it's not clear what that 50% means. Does it apply to the 8 or does it?
So he can be removed from the screen. People against Stephen James Valent, 25I-718-730.
Good morning, Your Honor. Michael A. Carpenter, 273, on behalf of the defendant.
Your name, sir?
My name is Stephen James Ballon.
So he says here, this is going to be a plea to OWI with the, I'm sorry, he's going to plead to super drunk count 2, I believe. Let me just double check that. He's going to plead to super drunk and the OWI count. That's count 1, actually. In fact, I'm going to move these. Give me this. Jeez. All right. He's going to plead to count 1 super drunk with the understanding that count 2 will be dismissed. There's recommended 24 months probation. This is not a sentence agreement, correct? It's not.
We know better.
And then alcohol screening and assessment, and then referral for sobriety court.
Yes, sir.
What was his blood or breath test again?
It was I think it was a 0.5.
Point what again?
0.5.
50 or something? Yeah, I kind of remember this. All right, so do you understand what's going on here?
Yes, Your Honor.
If you plead guilty here, super drunk, I'm going to take that plea. I'm going to dismiss the operating while intoxicated. I'm going to refer you for a screening and assessment, and we're going to get you on bond conditions for sobriety court. We're going to determine whether or not we're going to accept you. If you show an interest, and you show up, and you do what you're supposed to do, we're going to accept you. But I want you to understand by pleading guilty here that you could get up to 6 months in jail, minimum fines 200, max 700. Since your other prior was in 2014, right? You had 1 prior?
Correct.
I can't immobilize your vehicle and your license will not be revoked, but it will be suspended. Do you understand that?
Yes, Your Honor.
And did you sign an advice of rights form?
Sorry.
Take your time, read the advice of rights. John, no, right here on this plea form. Hand him that tab.
Sorry, Your Honor.
That's all right.
I'm ready on Van Leuven.
Hang on, Mr. Margolis. I'll get to you as soon as I can.
Of course.
All right, sir. Did you sign and read and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and we will not have a trial of any kind. Do you understand that?
Yes, Your Honor.
And you understand, have you been educated about what sobriety court entails?
Yes, Your Honor. I have a packet.
Did you read it?
Yes, I did.
Did you understand it?
Yes, I did.
All right, to the charge of operating while intoxicated, operating with a high BAC, how do you plead?
Yep.
On July 17 to 25, were you operating a motor vehicle on Meridian and near Macomb in Groseville Township?
Yes, I was.
Did you drink alcohol before that? And if so, what did you drink and how much?
Yes, I did. I drank 2 beers, 2 8% beers, and I drank the night before. I drank liquor.
You had 2 8% beers at what time?
At about 9 o'clock, 9:30.
In the morning?
Yes, sir. Yes, sir.
And how much did you drink the day before?
I think I had maybe 4 or 5. I'm gonna say 5.
5 what?
Vodka sodas.
Okay. And were you hand pouring these at home?
Yes, Your Honor.
Do you know how many shots roughly you were putting in each drink?
I do not know, Your Honor.
You said the breathalyzer of blood was 0.50?
So, Your Honor.
What else did you drink?
That is all I remember, Your Honor.
Were you pouring listen to me. You can't get there with 4 shots the night before
No.
and 2.8% alcohol beers in the morning. You cannot come close to 0.5.
Yep.
It's not even a contest. I mean, it's not even. So I need you to search your mind and tell me what you drank.
I was drinking, it was called Pink Whitney, that's vodka. And then I drank vodka, a bottle of vodka also.
So you had 4 drinks plus a bottle of vodka?
Yes.
Was that a 5th of vodka?
Yes, Your Honor.
The night before?
Yes, Your Honor.
And what time did you go to sleep?
I do not recall, Your Honor. Maybe around midnight.
Okay, and then you woke up in the morning and you had 2 beers.
Yep.
8 ounce alcohol. I mean, I'm sorry, 8% alcohol, 12 ounce, right?
Yeah.
And you were pulled over at about what time?
11 o'clock, 11:30
In the morning.
in the morning.
Why were you pulled over?
I hit a rock. I turned and hit a rock coming out of my condo complex.
Okay, was the rock off the roadway, obviously?
Yes, Your Honor.
Was it in your condo complex?
Right next door, Your Honor. I live right next to the gas station.
Okay, and so you're coming out and you strike a rock that's on the condo complex's property. Correct? How far is that rock located off the road?
It is located
Just tell me how far off the road.
maybe 10 feet.
All right. And did you call the police or did somebody else?
Somebody else called the police.
Police came to the scene, you went through field sobrieties. Was that a breath test or blood draw? Mr. Carmen.
Blood. They did a blood draw.
And do you stipulate that that was an accurate reading of 0.50?
They stipulate.
Are you on probation or parole right now?
No, I'm not.
Has anybody forced you to plead guilty?
No. Your
So you know you're gonna, and I don't mean to be harsh about this, you don't get in this program, you're gonna die. Have any of the sober link bowls been positive?
Right now, he's also been doing AA 5 times a week.
Good. Good.
I'd like to say.
All right, good enough. I'm gonna accept your plea. I find it to be an accurate plea made voluntarily and understandingly. So the plea is accepted to super drunk violation. That is operating while intoxicated with a high BAC. The OWI is dismissed. I'm referring you for a screening and assessment. We're gonna set this out. We have a graduation today. Do you work?
Yes, Your Honor.
Where?
At the Lincoln Center in Wyandotte.
What do you do there?
I'm a paraprofessional.
We have a graduation at 3. I'm not going to make you come because it's short notice today. But if you can make it, I'd love to have you here. This is the highest blood or breath result I've ever seen in my career as a lawyer or a judge. And I'm not trying to make you feel bad, but we got to take some action here. So Lisa, why don't we go out to about October 28th for sentencing, okay?
Okay.
And we can do that at 8:30 in the morning, Mr. Carmen. And in the meantime, you take them over. The bond is continued, all other aspects, and you're going to comply with any bond conditions that probation sets for you. You're going to immediately start testing, and you're going to have to pay for that. And then once we get you into the program, our grants will cover your chemical tests, your sober link. So weather the storm.
No, I'm sorry. What was the date for sentence?
October 28th. That should be a Tuesday, right?
Yeah.
Okay. You good that day?
Yeah.
All right. Good enough. Thank you.
Thank you, Your Honor.
Good luck. I really wish you well.
Thank you, Your Honor.
Unless Markila Cargill is here, I'm issuing a warrant. Do we have Mr. Williams? Lisa?
Yes, he should be here now. He has an exam, so he was on his way in person.
Are you here, Miss? Okay, I see. So he's. Kenneth August, Dan Louvet, 25W720941. Mr. Margolis, I'm not going to call your case if you're in a car moving. I'm sorry.
No, I'm stopped, Judge. I'm good.
Kenneth August Van Leuven, 25W720941. All right, Mr. Margolis, your appearance.
Elliot Margolis, P28078, on behalf of Kenneth Van Leuven, who is on Zoom and consents to being on Zoom. State your name, Kenneth.
Mr. Van Leuven, keep your voice up for me, please.
Yeah.
Talk.
State your
Tell me
name.
Yeah, I'm here.
Mr. Van Leuven, I need you to tell me your name, sir, please.
Kenneth Van Leuven.
Detective Cerna, your name?
Police Department, Your Honor.
I need you to keep your voice up. Not very well. Your name again?
Detective Cerna of the Wood Haven Police Department, Your Honor.
All right, so this is going to be an adjournment, so I can adjourn it to the 23rd, Mr. Margolis, the PCC, and the exam on the 30th.
Judge, if you can adjourn it to the 30th, because it's my religious holiday next week.
Okay. And then the exam on the 7th?
That's fine.
Mr. Van Leuven, do you understand what your lawyer, and I apologize to you, Mr. Margolis, do you understand what your lawyer just said?
Yes, I do.
You have the right to a probable cause conference within 14 days. He needs me to adjourn that. I'm prepared to adjourn it until September 30, but if I do that, that means you'll be giving up your right to have a probable cause conference within 14 days of the date of the arraignment. And furthermore, that also means that the preliminary exam will not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, I do.
Do you waive that right?
Yes, I do.
Anybody force you to do that?
No.
I'll accept the waiver. We'll set it for September 30, Lisa, at
9:30,
at 9:30 and October 7th at
11 o'clock.
at 11 a.m. for exam. And we will start right at 11, Mr. Margolis, okay?
Thank you very much, Judge. Appreciate you. Thank you.
All right, thanks a lot. Bonds continued. Have a good day. Thank you.
Thank you.
Do I have yet? Okay, Jeremy Scott Jordan, file number 24D232268. Good morning, Mr. Darren.
Good morning, Your Honor. This is Chairman Mr. Jordan, saving my life. Please say the record, sir. Chairman Jordan.
Okay, what are we doing on this?
Your Honor, we're walking in this warrant. He has a warrant on this for a duck license, and then he had it's a driving one with Judge Hessen. So
Does he stand me away from a reading? Why didn't you show up here, sir?
I was unaware of the warrant, Your Honor.
Do you live on Bloomfield Drive in Monroe?
Not anymore, sir.
When did you move from there?
February.
Of what year?
March.
March. Well, we sent them notices there in January. You got to show up in court.
Your Honor, I talked to him about that. I've represented Mr. Jordan in other matters, so when he reached out about these ones,
All right.
we got him.
Personal bond 500. Don't miss again, or you're going to have a lot of money in your pocket. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you want to go pre-try this?
Yeah, I figured Mr. here. I'll see.
He's here. This is his day. If you want to take, if you don't,
He might say something to the DNR case that might show.
well, that's fine. I'll tell you what. I'll let you take the file.
Okay.
Well, give me another date right now, Lisa, in case that then you don't have to come back in. What, you're good on the 30th?
This month?
Yes.
No, Your Honor, I have arbitration all morning.
Are you good on the 7th of October?
The trial.
Are you good next Tuesday? That's the 23rd.
Then Southgate.
You good on October 14th?
I'm sorry, Your Honor, I'm trying to help you out. If the court's okay with me being a little bit later, I have
What time?
a sentencing.
What time?
In Howell.
No problem. We'll make it 10:30. October 14th at 10:30. But if you resolve it, and that is a good date, right? At least October 14th at 10:30.
Yes.
Okay, Joel,
22 and a half. My numbers are correct. My math is correct. Okay, so minimum term sentence of 18 and a half. Maximum term sentence is 22 and a half. Okay, because that's the Reagan-Tokes rider on there for the indefinite term. You got me so far? Okay. Then the second case, which is 42560, that has an F1 on it, which is a maximum term 11 to 16 and a half is the Reagan-Tokes rider on that. That has the firearm specification of 1 year, and the MDO spec on that requires that to be a maximum sentence. So that would take away the discretion as far as picking between 3 and 11. I have to pick 11 on that one, plus the one on the gun spec. And then on this one, there's an additional 3 on the weapons under disability on that one. And then, and again, that case also has a second count, aggravated possession, which I believe would merge. There's also the carrying concealed and the improper handling, which are 1.5 each. So that's 18 to 23 and a half, if my math is correct. Again, I think it's at least fairly close. The other issue that is before, that would be before me on these two cases, because they're separate indictments, is that there would be a Reagan-Tokes case. In other words, there would be an indefinite sentence on both cases. So on the one, you're looking at 18 and a half to 22 and a half, because that one's a 4-year indeterminate sentence. The second case is 18 to 23 and a half, with a 5.5-year indeterminate sentence on that one. And then the court would decide whether these two cases should run concurrent or consecutive, because I have the ability to run these cases consecutively to each other, which would be then, and that's where the tough part about the Reagan-Tokes comes in. But then you're looking at 36 and a half. And I'm going to guess it's just going to be the one Reagan-Tokes that they would enforce, the longer one. And I'm just guessing at that because I don't know the answer to that, which would be 5.5. So that would be 36 and a half to 42 is what is, again, this is the worst case scenario, maximum, everything running consecutive to each other, which again, I don't know the case, so I can't really comment on whether that is. So I just wanted you to know what those numbers were. I'm sure the attorneys have talked at length to you. So I will just ask you, Mr. Adney, do you wish to reject this offer?
Yes, sir.
Okay, good. Now, the next question is, we have a jury trial scheduled on October 6th. And again, the issue comes up with regard to there being two separate cases. It's my understanding, and again, I just really found out for the first time that there are different witnesses, that these are two completely separate incidents. And again, I wasn't there, so I don't know. But they're going to be tried separately from each other. Okay?
Yes, sir.
Nobody has asked to combine them together. So I think the plan is that on October 6th, the state would proceed with presenting evidence on the first in time, which is the second indictment.
Second indictment, first in time, the December incident with the Highway Patrol.
Oh, so that would be case number 42560.
Correct.
Which is the felony of the first degree.
Correct.
Okay. So the question now comes, and again, we've talked a great deal in chamber. There's still this motion pending before the court for allow Mr. Travis to withdraw as your attorney. It's my thought, after talking to you last time, that I was not going to let him do it. You didn't tell me I guess to say the magic words, if you will, that would permit
You can let him
me.
withdraw, Your Honor.
What's that?
You can let him withdraw.
Well, that ends up causing more problems because,
Well, the thing is from what my other lawyer said and what he said is two totally different things. So I feel like he wasn't representing me from the fullest that he could in the first place.
I'm not going to get into that because attorneys, let's hear me out, Mr. Abney. I'm trying to be very patient here and make sure that you understand what's going on. I can tell you that both Mr. Travis and Mr. Engel are skilled trial attorneys.
Yes, sir.
So attorneys have different opinions and different interpretations. And just because they may tell you something slightly different, it may be different than what I tell you. I don't know. You see what I'm saying?
Yes, sir.
People interpret things differently. I can sit here like I just said that my opinion is that these weapons charges don't merge. Mr. Engel might sit there and say, yes, they do, Judge. But again, I'm just trying to educate you the best I can from right now. Okay. So if you consent and allow Mr. Travis to withdraw, I will not force Mr. Engel to go to trial on October 6th. So it's going to kick it down. It's going to kick the first trial down the road. You understand what I'm saying? It's just not fair. It's not fair to you, but he's not going to be ready in 3 weeks.
Exactly.
Does that make sense?
Yeah.
Again, if we want to go to trial on October 6th, Mr. Travis will stay on the case and I will allow Mr. Engel to assist him as co-counsel. So you'll have two attorneys representing you on October 6th. But again, I told them in chambers, I'm going to kind of leave that to you. I'm not going to force you to go to trial on October 6th. If you and Mr. Travis cannot communicate with one another, because that's important, right?
Yeah.
It's important for you and it's important for them.
Your Honor, I'm just going to be honest with you. I just don't feel like that he should be my lawyer anymore.
Okay, that's fine. Mr. Travis, your motion for withdrawal is granted and you may leave.
Thank you, Your Honor.
All right. So here we are, 3 weeks out, Mr. Abney. You're asking a continuance, correct, Mr. Engel?
Can I?
You can let me know. You can let me know.
Yeah, if I could just email the court maybe in the next day or two.
Yeah.
If
You
I can
guys
make
talk.
that work, I will.
Oh, that's fine. I'm not, but I'm just letting you know that I'm not going to force you to go to trial on October 6th. If you and Mr. Abney feel comfortable, again, we're just going to go on the second indictment, the first incident in time. So as long as everybody's clear with which, again, I don't know. So which incident we're talking about is the one that happened in December.
I think Mr. Engel understands.
Do you understand which one she's talking about?
Yeah, this is the one with the MDO spec.
The one with the MDO spec. Okay. So as long as everybody's clear on which one we're going on, and if you feel comfortable that you have enough information that you can proceed to trial. Again, Mr. Engel's tried many cases in front of me. I know his skill level. So I'm not concerned about that, but you two need to feel comfortable. So I'll let you guys talk. And at this time, I'll leave the trial on. But how soon can you let me know? Because I know Ms. Nicholson wants to prepare.
Yeah, within the next day, 24 hours, 48 hours.
Is that good?
Yeah, sure.
There's one issue with Ms. Nicholson we can talk about that may make things easier.
Okay.
Okay.
All right. Well, I'll leave that to you. And then with that, Mr. Abney, do you have any questions for the court, sir? I'm sorry?
No, sir. Thank you.
You're okay with Mr. Engel proceeding?
Yes, sir.
All right. Very good. We are adjourned. Thank you.